Lordship, a new motion. It has not been heard, Your Lordship. It's a very short point. Already in the previous round of writ petition, Lordship, an order has been passed in my favor. This is only for implementation of that order. Very short point. It may appear any day, my lord.
Give the number.
My lord, may I permitted to mention, let it be in the group 7 matter, let it be in the monthly list of July. My lord, this is the regarding dispute, my lord, regarding interstate permit.
It is not in the list at all.
No. Let it
It
be
is monthly list of
list of July.
This is new motion, my lord. Let it appear.
Yes.
New motion, my lord.
My lord, may I be permitted to mention, my lord, item number 1175 of the monthly list, my lord, for the state minister. There is appearing, my lord. I am catch.
Report, my lord. In that report, my lord, I have stated that the brought marketed and
Compensation. My lord, petitioner is 89 years old, my
Give
lord.
the
Hearing
number. Give
matter.
the number, please.
My lord,
the matter as
Monday, my lord, at for orders, Monday, my lord.
for 2 or 3 minutes it will be disposed.
Yes, my lord.
Monday for
As
orders.
Monday for orders.
My lord,
Be obliged, my lord.
may I be permitted to
It's
mention?
settled matter.
Yes, sir.
Most, my lord, more or less, my lord.
May I be permitted to mention one matter for inclusion in the list? This is relates to unauthorized enforcement.
It's in the monthly list.
No. New motion.
New motion. Give the number.
Released
May I
from
be allowed to mention on matter, my lord, under compelling circumstances. Yesterday also we have mentioned, and that in terms of my lord's direction, we have served the petition for dismantling the mobile tower. They are going to dismantle the mobile tower today, my lord. It is appearing as item number 155 in your lordship's daily list,
They are not going to dismantle today. I've seen the notice yesterday.
my lord.
They have asked you to dismantle by today.
That has
So after that, they'll take steps.
My-
So let us wait. And another very surprising thing that I found was that in the presentation form you have written before the department that I have directed it to appear today. Do you
No.
generally mention this in the slip?
No. Actually, what happened, my lord?
That has been recorded.
We have tried to file it, but the filing department has said that until and unless you write it, that Milo has given liberty, we are not going to file because they will not record it as that the matter will appear today. So they will not take the filing. That is why we had to note it down in the representation sheet, my lord. Otherwise, we would not have mentioned it. And at the second time also, at the second half also, we have mentioned.
So this is a lesson learned for me also. Next time onwards, I'll not make this statement at all.
No, well, I extend my.
It will come up in the ordinary course.
No, well, I extend my
Please
unconditional.
wait for your turn.
Well, I'll extend my unconditional apology, my
lord,
lord. Otherwise, they
This
would.
is not expected from a learned counsel, isn't
My
it?
lord, I
I
extend
was
my.
utterly surprised when I saw this yesterday.
My lord, I
How
extend
come
my.
you recorded this in the presentation form?
My lord, I extend my.
Do you do that in all the matters? You
No,
don't?
absolutely not.
then?
Absolutely not.
This is very unbecoming.
No, my lord, I extend my
turn.
unconditional apology, my lord. My lord, kindly allow me, my lord. Otherwise, they will.
Wait for your turn, let us see.
My lord, may I permitted to
Yes.
mention contempt application?
Give the number. Yes, call the days list, please.
Madam, may we permit to?
Yes,
WPA number 9198 has been
yes.
filed on 13th April, but previously it was in the list, but now it is not in the list.
Give
But
the number. Give the number. Please.
there's an update I am mentioning.
Please give the number. Please give the number of your repetition.
WPA number 9198.
You have to give us slip.
9198.
Yes, first matter.
And now.
Lord, I appear for the KMD in this matter. This matter has come up. Item number 1 and 2, one filed by my learned friend and one filed by Mr. Dhor. Mr. Dhor is for the vendor, his vendor.
Yes, yes.
Vendor challenges the acquisition proceeding, purchaser admits the acquisition and seeks for demarcation of the remaining land. So
My lord,
on
I
the
tell
last
you, Lordship, my lord, Mr. Thor categorically pointed out that his instruction is that he will not proceed with that
Right.
matter.
He wanted to withdraw.
Yes,
Yes.
that's why today the matter has been fixed. My lord, I have concluded my argument. Your Lordship was
Yes, sir.
supposed
Where
to
is- where is
deliver the
Mr.
judgment.
Dhor?
But Mr. Thor is not here.
My lord, your lordship can dispose of item number 1 as because I filed the.
They
My
are
lord,
running together, Mr.
Yes,
Sri.
yes.
running together.
Unless the other
but my
one
lord,
is
Mr.
disposed of.
Thor is a very unreliable person. My lord, in every court, my lord, he is not coming within the time. He is a very, for his cause, my lord, that is, he withdraw this application, that application. But on that day, he can't withdraw that.
My learned friend might have concluded his argument, but we are yet to make submission on for item number 1.
Your lordship here asked.
We have not said.
You have said, you have challenged the legality and validity of my deed, etc. What you are saying? Your lordship was supposed to deliver the judgment, then your lordship.
Just
Because
I have pointed out,
started
just-
dictation also.
Yes,
remember,
my lord
when
has
Mr.
started
Ghosh
dictation
said
in
that
my
he wants to
matter.
Come back with instructions to
Don't say
withdraw.
mislead the court.
not misleading. I
Shall I
just
make it
compare-
not today? It
compared
will
the
remain
date.
where it is.
My lord, what I will do, my lord, I will serve a notice upon.
Please do that. I'll just make
Yes.
it not today. I'm not
My
making any
lord,
order.
my lord, my lord.
Let it remain because it's a very short
Yes,
matter.
yes, my lord.
I started dictating also on the other day.
Yes.
But on the
My
other day,
matter, your lordship started dictation on law.
Or intervened and said he
Yes.
wanted to take
it
instructions.
is not conclusion of my argument. I wanted to show recital of the deed with the abutment. So some
So,
few,
I specifically recall that I had started dictating the order.
And he is saying this.
Anyway, I'll give you an opportunity. I have no discussion. I'll give you an opportunity. But please inform, that is more
My lord,
important. Please
I will,
inform Mr. Ghosh.
definitely I will today itself.
Not today.
Hey, I think.
Next.
Lordship, I appear on behalf of the petitioner. This is first time. I want to serve notice upon the respondent. The non-compliance of Lordship's Honorable Lordship's order dated to 22/3/2022.
Yes.
Non-compliance of a Lordship's order, Honorable Lordship's order 22/3/2022.
Appearing for the first time.
First time.
So will you
Yes,
serve and come back?
Okay, Lordship, I will serve.
Service direction. 20th July.
Grateful, Lordship.
This is for the restoration application.
Have you served?
No, I am
Not
for the respondent number 4 and 5, Birbhum Jila Parishad.
But I have filed an also section 5 application.
There's a delay.
There is a delay at the time of lockdown, my lord, it was settled for default. Well, let it be restored then, my lord.
Mr. Bandopadhyay was appearing for,
Statement.
let it be restored.
Yes.
Thank you.
2 of 2023, what's a delay?
841 days, I'm not objecting. I normally do not object. Non-minutes. I normally do not.
Petitioner.
But my objection may be noted.
সামাল দেবো
Objection টা note করুক, আচ্ছা মুশকিল, আমি করে নাও।
The petitioners pray for condonation of delay in filing the application for restoration. Learned counsel for the 4th and 5th respondents.
4th and 5th.
4th and 5th respondents raises objection to the contention of the petitioners. Paragraph, heard learned counsels for the parties. Paragraph, good grounds being shown, comma, the delay in filing the restoration application is condoned. Can 2 of 2023 is disposed of. 1 of 2023, this is an application for restoration. Huh?
24
Order to further. Disposed of. Are we ready to deal with the writ petition today? Now, here and now?
No, qualification outdated.
WPA order kurun. Let the matter appear under the heading Group 1 motion.
Group 1, man.
1 motion on 27th July.
Yes, 27 July.
Grateful man.
না আমি করতে চাইছি Well, let it be,
Yes.
let it be July first week.
No, July 1st week I will not.
First week.
I am ready today, my lord, but otherwise.
It has been restored, sir. Don't worry, it will be heard.
27 July, yes.
My lord, 6 to 19 is a
Yes.
similar matter, my lord. On the previous occasion, my lord, I pray for to file, my lord, report in the
Report.
form of evidence, my
You
lord.
are appearing for the petitioner in all the matters?
Yes, my lord, and I serve copy to them, my lord.
Yes,
Didi,
what is
আমার
the
এগুলা-
matter about?
Lordship, I am for the railway
Hey, now.
authority. Lordship, may I submit, Lordship? So just
Please,
yesterday,
the petitioner.
yes,
Oh, you're not ready today?
no, Lordship, I submit, Lordship, only yesterday, Lordship, the report, Lordship, by the joint
Didi.
inspection report in the form of affidavit have been served upon me,
Okay,
Lordship,
okay,
just
good.
yesterday, it's
You want to
14
go
matter,
through
Lordship.
it?
Lordship, and Lordship, I need
Yes.
1 week time to take instruction, Lordship. Initially, Lordship, there was a only 2-page joint inspection report. Now their authorities filing the state authorities filing the report, Lordship, in 14 matters separately, Lordship.
That same report, my lord.
The same.
Maybe
Same, my
Lordship,
lord.
but
Report is same.
and Lordship,
He wants to take instructions, let him come.
Yes, my lord.
You are for the railways.
railway, Lordship.
Didi ekটু নেন না?
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
পরপর বাঁধা আছে।
Do you want to use
সাজিয়ে
an
বাঁধা
exception
আছে।
to the report?
Yes, my lord.
You want to use an exception?
No, my lord.
No.
No.
On prayer of the railway authorities, the matter is adjourned. Let the matter appear under the same heading
14টা আছে।
on 27 July. Please be ready on the next occasion.
Yes,
That
it happened.
matter appears to be short, so we can dispose it of. Next. Till 19, same order.
Yes, Lordship.
20 my lord, I appear for the KMDA.
Petitioner,
Petitioner, I don't find the petitioner. Mr.
is
Anjan,
wrong today,
Mr.
Mr.
Anjan
Kalka?
Bhattacharya.
rainy day.
On the last occasion, also I don't find any order. Nobody is there. Nothing is there in the
Last
report.
petition also no one appeared, so let it be dismissed.
Nothing is, in fact, there is no merit in it.
On the last occasion, I do not find anyone appearing.
Yes, my lord was pleased to fix it on 26 today.
None appears for the petitioner, no accommodation is sought, dismissed for default.
Much obliged.
My lord, 21, my lord, I am praying short passover, my lord.
Not possible, madam. You are the
My lord.
petitioner.
Yes, my lord.
Passover is not possible. Make your submission.
My lord, brief is with my senior, my lord. Kindly, well, short passover, kindly, my lord.
Passover
take-
is not possible in
2
this
PM,
court,
my
I'm
lord.
sorry. On the earlier occasion also you took time. So you're not interested.
Kindly, my lord, my lord,
Several occasions you have taken time. No, no,
kindly, my lord.
please make your submission or it will be dismissed.
My lord, kindly, my lord, kindly, my lord, kindly fix it 2 PM, my lord.
Not at all. None appears for the respondents. On prayer of the petitioner, the matter is adjourned. Considering the conduct of the petitioner as appears from the record, the prayer of the petitioner is allowed as a last chance. Paragraph, let the matter appear under the same heading on 28 July, 28. Next. 28th July.
Whatever the state.
What is wrong today?
They have served a copy of the exception also.
You've received a copy?
Yes, madam.
Petitioner was there on the earlier occasion.
Yes.
None appears for the petitioner. Let the matter appear under the same heading on 1st August. 2nd August. 1st August should be. No, let it be 1st August. Until this 7th August. Oh, yes. What a date. First August. First August.
The 23 in this matter, my lord. I beg to appear for the petition of Mrs.
I
Maiti.
beg to appear on behalf of the petitioner of Imperial Lordship, my lord.
Yes, yes. Who is appearing for the respondents?
My lord, Your lord, the last occasion, my lord, I was praying before your lordship. The prayer before your lordship is this, my lord, the property in question belong to me, my Rayati land, my lord. Some people of the locality, at the instance of the government authority, they are not taking any step according to my representation. So what has happened, my lord, they are going to, in the name of implementation of the central government scheme, they are digging my land. And the property is question is low land, and that property is being dug, that is being now being going to be a canal.
Mr.
Again,
Siddiqui,
going to be a canal. So, my
File-
lord, I was praying with your lordship to stop digging
file
of my
the
land.
report.
My government is required to submit a report before your
Appearing in
lordship.
this matter,
Where is the report?
my lord, 1 week's times, my lord. My lord, 1 week's times, my lord. Kindly, my lord, fixed Monday, my lord. I filed the report, my lord.
In the form of affidavit, your lordship. In the form of affidavit, let there be report.
For time, he's
My lord.
asking for
Monday, my
extension
lord,
of time.
kindly, my lord.
Learned counsel for the state respondent seeks extension of time to submit the report in the form of affidavit as intended. Paragraph, let the matter appear under the same heading on 18 July.
18 July.
Huh?
180.
Great.
আমার
Next.
20 সিরিয়াল ছিল স্যার
23,
20
20 ডাকা হয়েছে, আপনাকে পাওয়া যায়নি, ডিসমিস হয়ে গেছে।
প্লিজ ম্যাডাম কাইন্ডলি করবেন
Fixed file. কে আছে other side? Who is appearing for the respondents?
এটা সার্চ করতে
Mr. Talukdar was appearing. Other side ছিল, তারা ওনারা চলে গেছেন, এখন অর্ডারটা দেখে কি করা যাবে, এখন কিছু তো করার নেই। মিস্টার তালুকদার স্টেটের জন্য কেউ ছিল না? স্টেটের কেউ ছিল না? মিস্টার তালুকদারকে একটু খবর দিলে আমি অর্ডারটা কনসিডার করব। হ্যাঁ, ওনাকে বলুন। মামলা ডাকার সময় থাকতে হবে আপনাকে, না হলে কিন্তু এইভাবে আমি রোজ কনসিডার করবো না।
আজকে দুর্যোগের জন্য পারিনি আসতে
Mr. Talukdar, the petitioner has appeared in person. State is not there, so let me fix a date.
অমিতাভ দাস
The matter which is, yes, item number 20.
20. ও আচ্ছা আচ্ছা
On the state's ground, let it be adjourned.
Let
এটা চেঞ্জ করুন তো, ডিসমিসালটা বাদ দিন। None appears for the state respondents.
আপনার তো
Let the
কোনো
matter
অ্যাডভোকেট
appear
ছিল
under the
না আমি
same heading.
না না আপনার ইস্যুতে পিটিশন তো ফাইল হয়েছে থ্রু অ্যাডভোকেট
না আমি ইন পার্সন
হ্যাঁ না না
Appearing in person.
ইন পার্সন অঞ্জন ভট্টাচার্য ছিল
নো নো পিটিশন ওয়াজ ফাইলড থ্রু অ্যান অ্যাডভোকেট
না তারপরে
Really?
উনি
Yes,
দিয়েছেন
that is-
ও দিয়ে দিয়েছে আমাকে
I'm not opposing, but for the
So now he is
formality
appearing in
requires that
person. So let the state appear, পরের দিন স্টেট এলে আপনার মামলাটা শোনা হবে।
স্টেটেলে আর এই ভোকাটা আপনাকে সই করে ফাইল করতে হবে
So
ডিপার্টমেন্ট
you must have the copy before the DP of. Suman Shekharito, my lord, was Maharashtra, sorry.
Yes. আচ্ছা,
And-
এর আগে স্টেটের জন্য যারা ছিলেন
হুম।
ওনারা এখন আর স্টেট প্যানেলে নেই।
আচ্ছা
আপনাকে জিপির অফিসে আরেকবার একটা নোটিশ সার্ভ করতে হবে,
আচ্ছা
ঠিক আছে?
আচ্ছা
Since there has been a none appears for the state রাখুন এটা। Since there has been a change of learned counsel in the state panel, the petitioner is directed to serve notice upon the office of the learned government leader and file affidavit of service on the adjourned date. And to notice serve করে affidavit of
আচ্ছা এই
service,
এই সার্ভিসটা দিতে বলেছিলেন দিয়ে দিয়েছে অফিসে
এটা কোন
ফার্দার
service?
ওই কেএমডি এই ছিল দিয়েছে।
শুরুতে affidavit of service.
আবার একটা আপনাকে দিতে হবে ওই জিপি কে সার্ভিস করে
হ্যাঁ,
আবার
সেটা
একটা
দিয়ে
Let the matter
At
appear
the
under
same time, my
heading.
lord, no objection has to be filed in the department. He has obtained no objection from his advocate.
He is appearing in person. This is not a change of advocate.
So that should be
He can
recorded.
appear in person. No difficulty. July 13,
এটা
voter file নেই। Fine. Next.
Thank you.
Much. I am for the petitioner, madam.
Respondents?
I have served your lordship, directed me to serve, I served. madam. This is against the input demand of royalty matter without measurement, physical measurement of the royalty matter. Sand,
Only state.
regard, only. There isn't a challenge matter.
Oh, you have served Mr. Soumitra Mukherjee, he was appearing earlier.
Only yes, he was appearing.
Is he still in the panel? No.
Nahin, এখন নেই।
Mr. Shamanto, bad luck. You have to serve.
Then I have to have again
GP's office.
chief office. In both the matters matter then.
ওই একই করুন। None appears for the respondents. Since there has been a change of learned counsels in the state panel,
তুমি জানি জানো,
the
এই,
petitioner is directed,
তুমি জানি
the
জানো।
petitioner is directed to serve notice upon the office of the learned double pleader and file affidavit of service on the adjourned date.
That's
Paragraph, let the matter appear under the same heading on
That he
19th
put
July. 19th July.
তুমি জানি জানো, দিয়ে দিতে কবি না।
You have to serve the GP's office. If no one appears, I'll request Mr. Dey. Service should be there.
Well, I served.
Notice.
Now there is alteration of matter.
So you have to serve a fresh notice. Next.
19th July matter, 19th,
কবে দিলাম? Rajesh?
19th July, 19th.
19th June.
Matter next matter same matter.
Next matter same. Same order.
I am for the petition.
Last occasion, lordship directed to file second report in the form of every. First we have some file my lord.
Field inquiry report.
Whether
report
about those
was
law-
directed to-
field
The
inquiry-
inquiry was not annexed. The field inquiry.
Yes, that has not been added in the earlier report. That is why lordship
What
directed
is
me.
the report?
Only 1 week time. I am saying. We have already informed her that they have not supplied the report. That is why only 1 week time. I am saying.
Learned counsel for the state respondents seeks extension of time to submit the report as called for. Paragraph, let the matter appear under the same heading on 24th July.
Yes,
Please serve an advance.
yes,
copy,
yes.
Mr.
sir.
Mukherjee.
Lordship, I'm appearing in item number 22, Lordship.
Miss the bus.
Lordship.
27 years.
Your Lordship, 27 to 33 are the similar matter, Your Lordship. Your Lordship, my learned senior friend is appearing. I have some copy to my learned senior friend, Your Lordship. Your Lordship, this is a
What
matter.
about the Union of India? Who is appearing?
Oshima something. Oshima Das. Oshima Das. She is appearing for Union of India, Your Lordship. Your Lordship, there are 7 matters of mine, Your Lordship, 27 to 33. Out of the 7 matters, in 4 matters, it appeared before my Lord Justice Kapoor, Your Lordship. And my Lord, as per my Lord's direction, Your Lordship, in 7 matters, out of 7, Your Lordship, in 4 matters, report has been submitted by Union of India, Your Lordship. And as my learned senior friend is appearing, my Lord has directed me to serve copy of all the copies to my learned friend. I have served it, Your Lordship. So, Your Lordship,
And then the Union of India is not filed there.
Lordship. Lordship, may I pray for one kind indulgence, Your Lordship? This item number 28, Your Lordship, there is a can application for substitution, Your Lordship. So that can be
I'll call one by one.
Lordship.
This is difficult. If the respondents do not appear, very difficult. And it will not serve your purpose if I dispose of the matter in absence of the Union of India, isn't it?
Lordship.
They are the answering respondents, I believe.
Lordship, Union of India's answers.
I'll give you a date. Please inform them once more.
Lordship.
The learned counsel.
Lordship.
None appears for the None appears for respondent numbers 1 to 5. Let the matter appear under the same heading. On 27 July.
33 months.
My lord, my lord, I prayed for kind indulgence, your lordship, item number 28. Your lordship, there is a substitution application. Lordship,
28 is 3538. বাকিগুলো নিয়ে নিন, same order হবে, Union of India নেই।
the petition is of Jibon Krishna Ghosh, your lordship. This and the can is one of 2020.
It's allowed. One of
Lordship, it was allowed.
2021.
Oh, I'm
One
sorry,
of
your lordship.
2021.
Lordship, yes, your
It's
lordship.
allowed, it's allowed.
The substitution has been allowed, your lordship.
Yes.
I'm grateful. So this can should not appear before your lordship.
Yes, it has been done.
Lordship. So this should be deleted, the can. Oh, khane thalbe. Lordship, 27th of July, all the matters, your lordship.
Till
33,
33.
lordship.
Same order.
Yes.
Lordship. I'm grateful, your lordship.
Please inform the learned counsel so that we can take up the matter on the next occasion. It's very unfortunate.
Madam, I beg to appear on behalf of the national user.
No, the state.
Petitioner, Mr. Pan?
My lord, Mr. Anshan Mondal is appearing for the.
এখানে এটা 35
ও, ওটা 35
হ্যাঁ।
আচ্ছা আচ্ছা এটা কোনটা
এটা অন্য ম্যাটার স্যার
34
সোমনাথ বিশ্বাস
ওইটা আমি নেই তো?
না না 35 তো
ও আচ্ছা না সরি মানে আই এম নট
Now, who is appearing for the petition? Mr. Onindo Bose.
মানে on the last occasion my lord, I filed my report, my lord.
Let there be a date. Petition was appearing till the last date. None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 1st August.
This is my application. Pursuant to your lordship's direction on 23rd of June. I have served a notice upon Mr. Anshan Mondal, intimating him that matter will be taken up today. Has received it.
Someone has received it also.
Yes, and my lord, kindly have your lordship's order dated 25th of April 2023. There is a
And the
specific-
council wanted to come back with a report.
For want of report, matter, the matter cannot be disposed of.
Let there be a date. Will you please inform him once more?
I-
It's very
I-
difficult.
Please
Mr.
take it up.
Mondal is never there. I should request the GP not to appoint him in any of the matters in my court at least. Very difficult. He is a very busy person, doesn't have time to appear before this court. I do not know. None appears for the state respondents. It's respondent number 1.
My lord, respondent number 1 is my lord.
Some
Union of
other
India.
council is representing
Union of India, my lord.
of India. He is also not there. One Mr. Shubit Mojumdar.
Yes, he is also not.
Well, actually, my lord, the respondent number 2 is the lordship, the answering respondent. As far as my knowledge is concerned.
Who is state?
2 is state, my lord.
But under the national highways, that is not the state, but is the
Is it-
state is,
huh.
there is the power
Power
to
to.
execute the thing, my lord, under the national highways act. So, my lord, Mr. Anshan Mondal is representing them, 2 and 3. They are the answering respondents.
None appears for the state respondents and the Union of India. Let the matter appear under the same heading on 20th July. Will you please take the trouble to intimate them once?
My lord, thank you. My lord,
My lord,
instead
2-0, my lord.
Instead of state respondent, my lord, kindly indicate state respondent number 2 and 3. Because under the national highways that.
Okay, 1, 2, and 3. 1, 2, and 3 are not represented. None appears on behalf of respondent numbers 1, 2, and 3. What about this? 1, 2, and 3.
Obliged. 20th July. My lord, may I take back the notice because that is. the only-
Yes. Notice the fail. 36.
36, my lord, in this matter, Mr. Omoleshwar is appearing for the municipality, my lord. My lord, I'm praying for only not today, my lord. Your lordship kindly, only not today.
It has been going on for quite some time.
Yes, sir.
Not today.
That's me.
Because the state is there, not today will not be correct. Let there be not. On prayer, you are appearing for?
Municipality, led by Mr. Omoleshwar.
That is 4 to 6. Yes, 4 to 6. On behalf of respondent numbers 4 to 6, the matter is adjourned. Let the matter appear under the same heading on 19th July.
Any day suits my.
19th July, as well.
Please be ready on this.
Circuit চললে আসবে না।
না, সাইকেল থাকবে না, স্যার। 15
But I am appearing for the petition. Your lordship's earlier order dated 7th November 2022.
Yes, further instruction was sought to be taken by the state.
Well, affidavit has been used by them. May not kindly have a look to the affidavit. This affidavit, my lord, is of dated 4th April 2023.
There is another affidavit of 2nd.
Yes, ma'am, that was the earlier. This is-
2nd December 2022.
Yes.
This is 4th April.
My lord, only whether he appeared, whether notice was served or not, only that point.
Yes. Fourth April affidavit, I do not find.
That is page 3, my lord, that is the.
A minute, please.
My lord, I will beseech your lordship to look.
I do not find that, Didi. Affidavit টা দেখুন তো। 18, 18 মাসে report in the form of affidavit. That's not. Report in the form of affidavit. পাচ্ছি না। এপ্রিলের।
দুটো অ্যাফিডেভিট থাকবে দেখুন।
May I be permitted to give my copy, my lord?
হ্যাঁ, এটা তো এফিডেভিট সার্ভিস। রিপোর্ট ইন দ্য ফর্ম অফ এফিডেভিট টেকেন অন রেকর্ড বলা আছে।
Affidavit as per order dated 2/12/22.
It's not appearing in the file actually.
Where the first affidavit used by the state,
That is on 2nd December 2022, isn't it? That is there.
After that, my lord, your lordship was pleased to direct me whether notice was given to them or not, my lord, before.
where this is, here it appears 11th April 2022.
ওটা না, ওটা সেকেন্ডটা।
First,
ফার্স্টটা তো হচ্ছে না।
না না, আমি ফার্স্ট আমার দরকার আছে রেফারেন্স।
11th April is a statement, not an affidavit.
That was paraphrase statement. Then not this affidavit.
This affidavit is on 2nd December 2022.
In December. Fourth day of August 2022.
Yes.
Third day of August 2022.
ওকে কি দিয়েছি?
Oh, this is mine, sorry, this is mine, my lord.
এপ্রিল দেখ, যেটাই লাইকালি।
2nd December 2022.
After that, there is another report, isn't it?
Yes.
That report is not in the
My lord,
file.
the fact is this, my lord, kindly have a look to the first, my lord,
Yes.
that is 11 and 12, they have dealt with.
Yes.
Because of that statement, my lord, the state was directed to file affidavit. Had given personal hearing to the writ petitioner, legal representative and passed a distinct order in miss case number such and subsequently copy of the order sheet containing orders passed by the district magistrate in compliance. Now, my lord, my submission was this. Paragraph 4, page 4 of the writ application. Kindly have a look to. And that's why my lord was pleased to direct the state to file affidavit. Paragraph 4, page 4 of the writ application.
Yes.
Nowhere they have dealt with. However, the notice is at page,
So you say that you appeared before the authority and you.
yes,
and you were not-
earlier, that was hard documents were submitted. I do not know whether order was passed or not, but no communication was there. That's why, my lord, the writ application was moved earlier. Thereafter, order was passed in the writ application. Again, the matter was heard, order has been passed. Where, my lord, in fact, title has been decided by the district magistrate, which he cannot do.
The order impugned is at page 98, 99.
Yes.
The 24th July 2019 order says that you were heard by the authority.
That is the second one, not the earlier one. But paragraph 4 of the writ petition, the earlier hearing that was completed, documents were submitted, no order was passed. I do not know whether order was passed because no communication was there. Then my lord, writ application was moved. Order was passed. After that, this order has been passed. I was heard, no doubt. No doubt.
So in the present writ petition, you have SL this order, is it?
Yes, exactly.
What are your grounds of challenge of this order?
My lord, page 16. Sorry, page 10.
Yes, Mr. Dey, can I have a copy of the last report that you have submitted?
My lord, that is only, my lord, whether notice was issued to them.
No, that is of the second. I do not deny that.
My lord, for that reason, my lord, it is not necessary now. Now, my lord, he is agreeing that
After the first hearing took place, there was a writ petition, there was a direction for a second hearing on the same issue.
is
So the first hearing becomes redundant. Why is
Yes,
it the first hearing now?
now, my lord, it is.
And now, my lord, in their opposition in the writ application,
The earlier writ application.
no, in this writ application, in the earlier writ application.
There
That
is
is
no
not challenged, my lord. Now he
Well,
challenged the
I-
order of the, that is the last order of
What
the,
was not looked into by the my lord, authority concerned who passed the order, my lord. So, my lord, that's why that also needs to be looked into. Because on this order was passed on the basis of writ application, opposition and reply. Now, what was their opposition in that writ application? No,
Have you
kind,
annexed it?
yes,
Have you annexed that? to the
Yes.
present petition?
yes, I have annexed. Lord, kindly come to annexure P8, page 49.
Page?
49. 49. I have annexed it. And my reply also I have annexed.
Yes, the relevant portion.
What they have annexed, that is at page 57.
There is no dispute with regard to this. There is no dispute with regard to this, page 57.
No.
Admittedly, it is acquired.
Yes,
They are not acknowledging your
exactly, exactly. And my lord, their own documents, my lord, that I have also annexed. That is at page 78. It is not my document. And page 93. Another latest copy of the record of rights issued from the office of the land department, that is on 23rd April 2020, 27th April 2023. Everything is fine. This is the
That
latest
is
one.
not the problem, my lord. Problem
Yes,
is, my
my
lord,
ownership is there.
my problem is there, my lord, entire order sheet is, my lord, if your lordship will come 97. What is the wrong in this order, my lord? Peruse the written submission of the learned advocate of the petitioner as well as those of the other parties and examine related copies of documents and past submitted by the parties. Also recall the earlier oral statement of the party. It is submitted on behalf of the petitioner that he purchased a quantum of land measuring 10 decimal in the suit
Yes,
plot.
that is recorded.
একটু দাঁড়া বাবা,
কর।
আমারটা আমি বলি তারপরে তুই বলবি। By virtue of registered deed, 10 decimals in the suit plot by virtue of registered deed dated 14 July 2006 from Samsul Sheikh my lord. Late Osir, and that is name of the recorded in the concerned record of rights with land revenue being paid number ato. The landed advocate of the petition denies that the entire 5.78 acre of land in the suit plot was included in the alleged partition deed being number 169 dated ato. According to him, 1.73 acre of land in the suit plot was included in the partition deed. The remaining 4.05 acre. It is further argued by the landed advocate that the title of the petitioner over the suit land has been admitted by the respondent in the affidavit in opposition filed in connection with WP number ato in the matter of Minara Khatun Bibi and ato. From the copy of the final degree in partition suit, my lord, that is ato Baharampur Murshidabad, that is the written submission of Ashim Kumar Bhatt. It transferred that the entire land in the suit plot was partitioned by meets and bounds among the owners concerned, with the plaintiffs, namely Binod Bihari Das and Suhasini Singho, having been allotted an area of more than 4.05 acres in the suit plot by the learned court's order. By a deed being number ato 26, the aforesaid plaintiff transferred ato acres of land in the suit plot for Ashim Krishna Bhatt and Pintu Pal, who subsequently transferred through different registered deed some quantum of the land in a number of person, namely Kakuli and other thing. By virtue of the above mentioned partition suit, the remaining area of 1.73 acre in the suit plot went to the defendant, including Ostur Sheikh. That is, my lord, he purchasers, vendor of the this writ petitioner, my lord, father of the vendor of the writ petitioner, Ostur Sheikh, my lord. Saraj Sheikh, Shamsher Ali and Ato. These 1.73 acres in the suit plot is found included in the alleged partition deed being number 169 dated Ato, as is clear from the comparison of the respective case map forming parts of the aforesaid partition deed and the final degree. By partition deed, the land measuring 1.70 acres was allotted to Siddhartha Shankar Bhatt, Asadul Haq and others. Thus, the above analysis gives a complete account of the owners of the entire 5.78 acres of land in the suit plot in the acquisition, which is the acquisition is not challenged by the. Now, when land measuring ato acres of land out of total 5.78 acres of suit plot was acquired under LA case number ato, PH Department compensation award was duly finalized in the name of the above mentioned landowners. On the basis of their supporting documents and position, award money was fully paid to them, followed by delivery of possession of the acquired land to the requiring body. Now, my lord, for the petitioner, it transpired that the petitioner was not considered as an awardee, as his name was not found in the concerned land schedule relating to land acquisition by the case number Ato, which was prepared on the basis of the copies of the latest land records collected from the LRO officer of the Ato, finalized after proper inquiry. After that, my lord, it is noted that that is, my lord, very.
So, Mr. Dey, in other words, your claim is that you have paid the compensation to the vendor.
Yes, my lord.
Any document to show that?
Yes, my lord, I can show.
Petitioner cannot claim.
Now, my lord, petitioner has not a
No,
right. That is
just-
a.
May I interrupt for a moment? My learned friend submitted by reading out the order sheet that I'm just defendants including Qatar Sheikh, Sarej Ali, Shamser Ali. I think if I have not heard otherwise, father of the petitioner.
Father of the petitioner, not.
No, because
Postur,
Not father.
Postur is the
Father.
vendor of the
because my
Father
lord,
of the vendor.
vendor.
because my
Father of
lord,
the vendor.
in the partition suit, this writ petitioner was not made a party.
The vendor was a party.
That's true,
The
but I was
vendor's
not
father
made.
was a party.
I was not made party. Everybody has been given, have been given the compensation.
The vendor's father was a party. The vendor or his father has been given compensation. The petitioner comes subsequently.
No, kindly come to page 42. First notice. Sorry, not page 42. Sorry. I'm coming. I'm just, not page 42, page 23. This is the notice, first notice, acquisition and compensation. Name of the petitioner was there.
কি দেখাচ্ছিস?
Petitioner,
কত কথা?
page 23.
Yes, how was this? No, I think the matter needs to be heard on affidavits. Matter needs to be heard on affidavits. How was this notice issued?
Yes.
In that case?
Yes.
You have correctly pointed out.
And we
Page 23.
will kindly have a look to page 38 of the writ petition. They are changing their stance day after day. Page 38.
Right. This is also to the petitioner.
Exactly.
Mr. Dey, Will
Exactly.
you come back with a comprehensive affidavit?
Exactly. Let them come up with a affidavit.
There are contradictions.
Yes, my lord, I have.
Third learned, Third learned counsels for the parties. It appears that the matter needs to be heard on affidavits. Paragraph affidavit in opposition be filed. 2 weeks, Mr. Dey?
My lord, my lord, as the panchayat election is there, my lord, all the officer has the, so my lord, 4 weeks.
Be filed within 4 weeks from date. Stop affidavit in reply, comma, if any, comma, be filed within a week.
Within a week.
Within a week thereafter. Paragraph, let the matter go out of list for the time being, liberty to mention.
Or my lord, let the date
Not
be
possible without affidavits.
Oh, God.
Has to be.
liberty to mention. Obliged to.
Next.
I appear on behalf of the petitioner.
But I'm for the state. But only difficulty is but in this matter, Mr. Jawaharlal Dey was leading me.
Yes.
Lordship is about Mr. Dey is not in the panel right now. Brief is lying with Mr. Dey. So one
You are appearing.
Yes, my lord, the brief is lying with the sister. I have to collect the brief.
So you can take necessary steps.
Yes, my lord. Well,
No
kindly,
fresh notice is required in that.
no fresh notice is required. My lord, only I have
Let
to
him come.
take, yes, only one accommodation.
Next, let it be taken on next place.
I'll give you a date.
Okay.
On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 19th July. 19th July.
I leave it to my. 19 July.
Next.
Sure.
Next.
About the petition, Your Lordship. There was a direction upon the state to submit a report in the form of affidavit, Your Lordship. On the state and highway, I have received the copy from the National Highway, Your Lordship. I have yet to receive. Yes, I have received the copy from the National Highway.
Mr. Dev, several extensions have been sought.
Lord, be a last chance, madam. I'm very sorry to say.
Taken several adjournments, Mr. Dev.
I know, my lord.
Learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as called for. Paragraph as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 24th July.
Malad,
Paragraph-
39 and 40, Malad, the same.
Paragraph report be submitted on the adjourned date upon service of advance copy to the petitioner and the NHAI.
Item 40, same matter, Your Lordship. The state advocate is Shishana Bandapade and Arpa
40.
Kumar.
40, Malad, 39 and 40.
The advocate is different, state advocate.
I'll
in
just-
item.
Here also report is awaited.
Yes. There's the same direction, Your Lordship.
State is not appearing at all in this matter.
No, initially they were appearing Shishana Bandapade or Orko Kumar Nag, dated 24/3/2023. They are appearing, Your Lordship. Was it same?
Who is appearing for the fourth respondent?
SUVRA Bhattacharya and Shipra Shatra was there, Your Lordship.
No, they are also not there.
Because of the change of panel, many juniors, those who are not there. Notice upon the learned DP.
No, he's always in the panel. Shishana Bandapade is still in the panel. No.
Orko Kumar.
We cannot take the plea of change of panel in every matter, Mr. Ganguly. We know that that's a difficulty.
যেগুলোতে হচ্ছে সেগুলোতে Lordship দিচ্ছে।
Yeah, I am also facing. Because the entire papers are with it.
No, they are very much in the panels. Still, they have not they have chosen not to appear.
So let him serve a notice one day, he'll come tomorrow.
That tomorrow has gone by. He is not appearing for the last two occasions. Next day, if he doesn't appear, I have to write to the GP.
Your Lordship, only one harm, so let it be recorded as a last chance. If not, then it is a hard ex parte. I'll serve the same to the GP, Your Lordship. What is it?
40.
Item 40.
None appears for the state respondents. Let the matter appear under the same heading on 25th July.
Malad, the same matter, Malad,
Same.
24th.
Oh, yeah, same matter.
24th July. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the state respondents.
Oh.
Malad, the same order in 39 also.
Let it, 39 and 40 same order.
No, that's
No, oh, sorry.
39, Mr. Dev was there.
no.
No. Next.
Well, this is my application signed for the petitioner's hearing. Well, the petitioner was in an auction proceeding. The petitioner was become a highest bidder. And as per the rule of 10-1, West Bengal minor auction rules, the one third installment has to be deposited within 15 days. That minor, the petitioner has failed. On the grounds, the petitioner was at that time had to go for Chennai for surgical operation and made an applications that give some times, but that has not been considered. Ultimately, the highest bid has been cancelled. Then minor, the petitioners again made an applications for making a deposit of the installment. Now, as on that lordship, the petitioner has paying that the the petitioners intend to 50% of the bid amount pay if the lordship is direct subject to approval, my learned friends. And this is why the in order lordships kindly come the page 32, the demand and hearing notice. And as per this notice, the petitioner made an applications on 17 May. The petitioner's office.
Sometime in 2021.
Yes.
Yes, 2021.
Cancellation order,
E-auction?
August 26.
August and January 2021.
Tender invited in January.
January.
21.
The bid was cancelled. Lordship kindly come to page 35. 26 August 2021. Then my lord, I again made an application on April 2022. As on date, lordship, the land has.
Did you reply to the page 32 application?
Page 32. Lordship.
The 12th March application?
Lordship,
The
that the page 34. Page 34, lordship, I made an application stating that I was ill and I had to go for Chennai for operations. And fact is that the land is still has not been put in auction. Now the petitioner is ready to pay the 50% of the bid amount. If the
You have not complied with this demand notice also. You were supposed to appear within on 30th March.
Lordship, on
And
that
you have
I was not appeared because that due to illness the petitioners could not appear, and that's why the petitioner made these applications, and that's why lordship the highest bid has been cancelled. It is admitted that I have violated the rule. But as on date, lordship, the fact is that the land
You are
is
only asking for sympathy.
sympathy, lordship, and nothing there. As on date, lordship, the land has not been put in auction, and now the petitioners intend to pay the entire bid amount even within a period of specified period as the lordship defeat.
Yes.
Well, he filled all the terms and conditions, my lord. He was given opportunity of hearing.
Admitted.
Admitted.
He's only asking
He
for mercy.
appeared. He appeared, but not submitted, my lord, any documents or anything, my lord, and not only expressed his inability to pay.
No.
But thereafter, my lord, it has been cancelled. If it is, my lord, cancelled, there is a provision of appeal. He may prefer appeal before the appellate also.
Was the order impugned passed after hearing the petition? Page 35.
Opportunity to hearing was given to him. He was not appeared. Annexed P3, page 32, demand subject. Demand come hearing notice for deposition of 1/3 bid amount against auction such and such. Last paragraph, my lord, however, you were given the last opportunity of being heard on 19th March 2021 at 11:30 AM, and accordingly you are requested for the above payment to appear before the undersigned along with the paid challan deposition such and such. But he has not availed it. আমাকে যা ইনস্ট্রাকশন
A representation of the petitioner is pending.
Pending.
Will you consider that? That is all that the court can
there
do.
is a provision of appeal, but he may prefer appeal under section 51. Rule 51. And the minor concession rule.
against the cancellation order. That was also in 2021.
Your lordship may condone that.
Writ petition is in 2022. You are not interested, sir.
Lordship?
Why?
Lordship,
The order was in 2021.
Lordship. Lordship, the
Order-
representation was made on Lordship April 2022. After
When was the order passed? 26th August 2021.
2021,
So
Lordship,
you again sat tight over it.
Lordship, this order has been most probably
Suddenly
communicated
you wake
after
up from slumber and decide to file a writ petition. Oh,
Lordship, actually, Lordship, this order was communicated after 2
Order,
months or 3 months.
maybe
Thereafter,
even if
Lordship,
it's 3 months, it is September, October, November. This is in May 2022.
Lordship, there was
You
3
have
months,
no
4 months.
case at all. The court really cannot help you.
So,
I can only request the authority to consider the representation. That's all.
Lordship, then my lord, kindly give my liberty to prefer appeal because the appellate authority as per rule and the condemnation of the delay.
Let the delay be condoned.
This is the only way because the
Yes.
representative rules concerned again rejected. Again, I have to come. The affidavit service kept to the record.
The petitioner has assailed the order of issue the affidavit search. The order impugned passed by the district magistrate Purvo Bardhaman on 26th August 2021, cancelling the bid of the petitioner for grant of long-term mining lease and forfeiting the amount deposited by him for participating in the auction. Paragraph, the petitioner seeks to withdraw the writ application and approach the appropriate forum for redressal of his grievance. Appropriate forum in appeal court. Appropriate appellate forum. Approach the appropriate appellate forum for redressal of his grievance. Paragraph, in view of the above, the writ petition being WPS such as dismissed for non-prosecution, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner files the statutory appeal within 15 days,
15 days.
within 15 days from date, comma, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of limitation. There shall have been orders.
Yes, sir. Subject is affected in earlier occasion, madam.
May I check it up, my lord?
Yes, completed.
Yes, sir.
Yes. Twofold grievances are there. One is selling out the earth from my plot of land, and that is converted as very forcefully. It is not that my consent. So the conversion of very my lord, forcefully that I am not disturbing your lordship. So we're selling up the earth by digging up the earth or taking away the minerals. That comes within the purview of minor minerals rules. Because nobody can extract any earth without any permission from the authority concerned. The representation was made to the effect of the district magistrate. District magistrate initiated a proceedings. That my lord will find last page, page 75 P7.
Page 75.
Page 75, page 7, last. But one. My lord got it.
Yes.
It is directed. Action report, action taken report.
The officer in charge.
Yes, yes. Because he is the authority to oversee that whether it has been done. Because it is the lawfully, my lord, nobody can extract any art without the permission or the payment of royalty to the block land reforms officer. My lord knows better than us, my lord, so far this is concerned. My allegation is twofold. One is lifting the earth without my permission or any authority. Second, conversion of the land by it is a very. And yes.
Conversion part will not be dealt with. by the-
That's why, my lord, I am very beginning, my lord, I have submitted. The twofold grievances are there. One is, and so far, my lord, a report was also made by the concerned revenue inspector from where it appears, yes, my allegations are correct, but it is not a part of the record, but it is I can supply a copy to my lord.
Have a copy of the report.
Yeah.
It was given to you.
Yes, yes.
Certificate copy.
The certificate copy I have obtained. My lord, the revenue inspector. একটা copy আছে?
That is the change of character.
Yes, because unless until the earth is taken away, the mud cannot be, earth cannot be located there. It is taken away by the private respondent and conversion is there. I am not on the conversion, but there's a earth which has been taken away. That cannot be done without under the mindset minor minerals rules. And it's categorically held that this report is sent for
Yes.
the allegation is true. And concerning that they may initiated a
But
procedure.
representation has been filed by you.
Yes,
The
yes.
DM has taken some steps.
Yes, yes, yes.
So will you come back with a report?
Why not even consider that representation one?
As well. Is already directed.
Where is your,
Lord,
Yeah.
ADM is the authority for the royalties purpose. So
My lord will
ADM
find my representation is at page 56. Lots of parcels are there. But my lord, I might be candid before your lordship. It should be the
plot number 12 by
yes, yes, only.
56.
plot number 12/84.
Page 56.
48.
Key.
Representation. plot is তোমার?
হ্যাঁ, ওই দুটো your lordship will find page 48, P4.
My lord, ADM will consider, not DM. In my lord, royalty purpose, if you want.
Yes, that's why it was reported to the BLLRO. That is why the revenue inspector,
ADM is the
as your lordship.
additional estimation.
So let the ADM consider page 48, this representation.
ADM की party আছে, the district land and land reforms officer is the
হ্যাঁ, ওই তো।
district land and land reforms officer.
Land and land development officer, ADM
He's
is
the
the-
ADM,
Yes,
the DLLR.
but I did not mention it as an additional district magistrate. That's why I will. DLRO is the authority.
Yes, ma'am.
The next representation is what Mala to the DLRO. That is at page 56. Mala will find. Mhm. But may I submit one thing? The representative is not so happy in the.
So please file a comprehensive.
Yes, yes, yes. That's right. Because it is something not very happy. That's why I did not draw your lordship attention to the
Comprehensive.
not very comprehensive. The allegations are
Let him come with a fresh representation.
yes, my lord. Within 7 days, my lord, I will file. My lord.
চাষটা কম লিখে
পুরো
Third learned counsels for the.
জানি এটা
parties.
জমিকে জমি ইয়ে করে দিচ্ছে।
সবসময় বলে দিই।
এবারে JCB আসে।
আরে না, সব
Claims to be the recorded owner of the lot in question and complaints.
উত্তরা
And the
অন্য জায়গায় হচ্ছে।
private respondent has been excavating earth from the said plot
Ready.
without
না, অন্য চাষ হচ্ছে না, চিংড়ি চাষ।
শুধু চিংড়িতে। আসল তো লাভ চিংড়িতে। বাগদা, গলদা।
has been illegally excavating. Has been illegally excavating without permission of the concerned authority.
নিজের জমি কিছু করার নেই এবার 11 দিকে নোনা জল ঢুকে দিচ্ছে জমিতে নষ্ট হয়ে যাচ্ছে নষ্ট হয়ে যাচ্ছে নোনা জল ঢুকে দিলে কি করবে?
The petitioner seeks to
জল নিয়ে এলে
submit a comprehensive representation
ঠিক আছে একটা কপিটা দিয়ে
ওখানে একটা permission of the concerned authority, comma, thereby
Response number 3, District Land and Animals Officer. Response number 3.
changing the nature and character of the land from agricultural land to a water body.
Very. Malar Kali record that very for the purpose of very.
To water body bracketed very, VHERI.
Forcefully without my land converted by others, private response.
The petitioner seeks to submit a comprehensive representation before the
Response number 3, District Land and Animals
third
Officer.
respondent in this regard and prays for a direction upon the respondent to the said respondent to consider the representation at the earliest. Paragraph, upon consideration of the submission made on behalf of the parties, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the third respondent within 7 days. Within 7 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 2 months. Within 2 months from the date of from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Ekdom shurute korun. None appears for the private respondent and the none appears for the 10th and 11th respondents. None appears for the 10th and 11th respondents despite service.
Malar, may I get back the original report so I can file the photocopy? It is just a photocopy.
This is not necessary, in fact.
Because I have handed over, that's why.
No, I would have given it back.
Grateful to your lordship.
Original to ফেরত দিয়ে দিন। Original to ফেরত দিয়ে দিন। Original certificate.
Grateful to your lordship.
Yes, next.
Sir, this is my application. 43. And the petitioner land was accorded by the railways board.
Have you served the respondents?
Lordship. I file evidence service.
Who is appearing for the respondents? There is no one for the respondents. Let there be a date. It will be considered even in absence of the respondents on the next occasion. Please intimate them. None appears for the respondents. Let the matter appear under the same heading on 27th July. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents.
This is also my application. Well, the petitioner land was acquired by the Indian Railways.
Respondents, Mr.
34, I'm for the state.
My lord, it is
Land was acquired by the state.
acquired for the purpose of Eastern dedicated freight courier by the Eastern Railway. And my lord, compensation was paid in the year 2016. Then being agreed by the compensation, the petitioner moved the writ petition before the honorable court for market price of the compensation. And then this was disposed of by this honorable court by directing the respondent number 4 and the competent authority to take a decision. And that decision they have taken. My lord, this decision is under challenge before lordship. Welcome.
Who is appearing for the railways?
Well, Mr. Subbosaji Rajudhira, I informed him over phone. I have also sent a message through WhatsApp, but unfortunately, he's not yet
সব্যসাচীরা যদি 11-তে বসে কোথায় বসে জানি না, আমি মেসেজ পাঠিয়েছি মনে আছে বোধ হয়। না না আছে। So if your lordship directs me, I can serve him 1 second, because the earlier matter was also regarding that the cause of action is the same.
Let it appear on the same date. On the next date, even in his absence, it will be
Lordship.
different. The
My-
court cannot wait day after day.
Well, in that case, 44, 45, 46 also same.
43 to 46.
Yes.
Manifest for the railways, let the matter appear under the same heading on it. 27th is the date I gave you.
Yes.
27th is same date,
27th July.
27th July,
My lord, instead of 27th, can it be 28th?
28, very well.
28th.
In all the matters, in the earlier
Yes,
matter
yes,
also,
yes, yes.
Arbiter 28,
43 to 46.
28 Corona Arbiter, 28 July. It is made clear that the
43
matter
to
may be taken up for
46.
consideration on the adjourned date, even in absence of the railways.
Lordship.
That's it, Mr. Kawal. I'm not taking state case.
Yes.
45, anyone for the state?
43, 44, 45, 46. 28th of July.
I want to call one by one.
Lordship, lordship.
45, no one, you are,
I am for
Mr. Day for the state. None appears for the railways. ठीक है, इधर आगे लौट जाओ. In absence of the railways. 28th July.
I'm for the petition.
No one for the state. None appears for the respondents. Protham Dharmatan Arun.
I am on behalf of the respondent number 4 to 18, madam. 4 to 18, I am filed opposition, madam.
Presentation ছিল?
No, no
direction. ঠিক আছে,
Was an opposition called for?
I am for respondent number 4 to 18, madam.
Yes, did the court direct submission of filing of opposition?
আমি তো বললাম না। This is a dispute regarding the entitlement of the compensation in respect of the land which is subject matter acquisition under the National Highway Act. We have raised our objections so far the land which was recorded in our name, and we are also claiming title over the property. The private respondent also disputed my title over the property, filed a proceedings for in the record of rights for correction of recorded rights in their name. Those proceedings are pending with the LRTT. Now, my lord, we filed an application with the authority concerned that we are the recorded owner. So either you should accept me or you have to send for decision of the authority concerned. Now, my lord, you will also only consider the last but one page, page 39. The district magistrate has called for hearing. Page 39, P7, my lord, will find. Pursuant to this objection, counter objection, my lord.
Yes.
Hence the urgent meeting, fourth observation, my lord.
Land
Whereas the
has-
additional stretch,
Possession of the land has been taken.
Yes.
Position, and we are
That process is complete.
that they are now.
You're only on compensation.
Now, my lord, we cannot, my lord, in view of the fact, my lord, it cannot be done. Now, my lord, we made it represented to that effect. My lord, next page, my lord will find. This is a notice issued under section 3A of the National Highway Act. Next page, my lord, I don't know whether it is legible to my lord's copy or not, because my copy is very much illegible.
It can be read.
Page, next page. There, my lord, your lordship find a hearing was given. নিজের উপর অনুকূলে প্রমাণ হিসেবে যাবতীয় কাগজপত্র দস্তাবেজ অধিকার কাগজ কোর্ট কেস নিয়ে যে ডিএলআর জয়পুর অফিসে উপস্থিত থাকিবার জন্য কার্যে সহায়তা করবে। So this is my lord the adjudication regarding the entitlement of the compensation. After that nothing has been done. দাঁড়া আমি বলছি। And page 37 is a representation of the district magistrate, because the district magistrate initiated the proceedings. My lord will find the first copy of the district magistrate. Second is under the authority under the section 3A. Either they have to take decision in terms of 3H3. If they found that yes, they have no case at all, then this was to be. If they found that the integrated question of title is involved regarding my claim, then they have to refer the matter before this. This is the only thing they have to do. Record of right দেখে এখানে কি জজ এখান থেকে দিয়ে দেবে নাকি? হ্যাঁ বলুন রেকর্ড।
Yes.
Well, my client purchased the land, my lord, from the grandfather of the petitioner, my lord. As per registered deed, my lord. I made an application for the BLRO for correction of the record of right, my lord, but has not done, my lord. I filed the application before the elected land reform tenancy tribunal. That is pending, my lord. Kindly see, my lord, I am prepared a opposition, my lord, details.
Not
My lord.
necessary.
Can I direct to me, my lord, to file a report, my lord?
That is, Mr. Dev.
My lord, he filed an application before the authority will
Let the
consider.
representation be
Yes,
considered.
yes.
But also
And
give
all
an
his-
opportunity of hearing.
Normally, I recorded on, my lord. I have a record, my.
Opportunity of
We
hearing by the-
we are also filing the record of rights. So
Kindly accept, my lord, opposition and that's a direct, my lord. Kindly direct, my lord, to file opposition, my lord. I file.
Necessary.
Kindly file opposition.
The court doesn't feel it necessary, sir. Appear before the authority, you'll be heard.
yes,
Raise your
CH3,
case before the
CH4, he is the one of the authority to state forth his claim.
DM করবে কেন?
এখানে দেখুন প্রসিডিংসটা ইনিশিয়েট করছে ডিএম, আমি সেই জন্য করেছি। আমি কম্পিটেন্ট অথরিটি করে হওয়া উচিত না, কিন্তু দেখো এখানে প্রসিডিংস ইনিশিয়েট করেছে।
হ্যাঁ।
But one thing, my lord, na, page 39, the proceedings has been initiated by the DM. But under the National Highway Act, my lord knows better than us, my lord. Competent authority is the ADMLR. Though it is proceeding initiated by the DM, so I made the DM as a party.
ADM DLLR is not.
If my lord wants, give me leave, so I can add him that
I
part.
think ADM DLLR is the.
Competent under the statute, but here the proceedings has been initiated by the DM.
Let it be added as a party, let this be sent to me.
Grateful to your lordship. Because it is my duty to point it out to your lordship.
Leave it. ADM, LEM,
On prayer of the
ADMLR.
yes, ADM,
Competent authority and
petitioners, liberty is granted to impede the
আমি লিখে দিচ্ছি address.
additional district magistrate and district land and land reforms officer, Purulia, as respondent number 19 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph. It is not in dispute that the plot in question has been acquired by the state respondents
National Highway Authority, one state.
by the National Highways Authority of India, and possession of the plot has been handed over to the requiring body. The petitioners claim to be recorded owners of the said plot and have filed and have submitted a representation before the concerned authority on 11th July 2022 seeking compensation in lieu of such acquisition. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the private respondents submits that the private respondents have acquired title in respect of the plot in question by virtue of purchase from the predecessor of the
Yes, my lord. From the grandfather of the petitioner, my lord.
from the predecessor in interest of the petitioners.
By registered deed, my lord.
Paragraph. Learned counsel for the state respondents submits that the 19th respondent, 19th respondent be directed to consider the representation submitted by the petitioners in accordance with law. Paragraph, in view of the above, this court is inclined to hold that since there is a dispute with regard to title in respect of the plot in question between the petitioners and the private respondents, and a representation submitted by the petitioners before the concerned authority is pending, the concerned authority, being the 19th respondent here in be directed to consider the representation within a stipulated time frame. Paragraph, accordingly, the writ petition is disposed of, directing the 19th respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Paragraph, both the petitioners and the private respondents shall be at liberty to place relevant documents before the concerned authority in support of their respective claims at the time of hearing. Paragraph, it is made clear that this court has not gone into the merits of the case, and the concerned authority shall be at liberty to deal with the representation independently upon consideration of the documents placed before him, as well as upon hearing both the parties, and without being influenced by any observation which may have been made in this order.
May I
This
pray
was
with your lordship, inviting your lordship to say under section 3H, because my lord, then my lord, only order will be passed, no consequential steps will be taken. If the authorities of the opinion that I am entitled to get 3H3, I'll get the compensation, or he get the compensation.
Paragraph,
If the authority found that it is not
authority
resolved,
is directed to take all consequential steps
in terms
upon
of 3H,
disposal of the
yes, ma'am.
representation.
Because then the money will be there and only the order will be passed.
The authority may also wait for the decision of the, so let me not record 3H, let them take consequential.
Yes, yes, yes. Consequential order, we can
He
impress.
may choose to wait for the decision.
Yes.
Disposed of?
Leave may be granted to.
Yes, sir.
Yes, ma'am.
The decision taken by the authority shall be communicated to the petitioners within a week there.
Happy birthday, sir.
Shall be communicated to the petitioners within a week. Therefore, it is-
I appear for the KMD in this matter.
Noted, my lord, Mr. Shamimul Badi appearing on behalf of the petitioner, my lord. My lord, he is engaged in court number 25, my lord.
This is that matter, my lord. The petitioner is to make submission on the point of
Public
maintenance.
interest litigation. Let him come back.
Let him come up.
On
Fix it
care
on
of
some
the
other day.
petitioners, the matter is adjourned. Yes. Yes, so what have you decided, sir?
Last occasion, my learned friend raised the maintainability point regarding whether the association can maintain the REIT application or not.
The nature of the
Yes,
public
yes,
interest
ma'am.
litigation.
Your lordship would ask me to come with authority. I shall place to judgment this effect. The division bench judgment. No, it's a,
Report it.
it's a single bench judgment.
Report it. Report it. Report it.
I do not know whether this is reported or not, but
Better copy the order.
from the second page, my lord.
Yes,
From the second page, my lord, may I read or
paragraph?
first from the first paragraph? Mr. Mojumdar.
Yes. This is not the issue at all in the present petition. The issue was not whether the society could have filed the application. The issue was that this is a public interest litigation. Society comprises all the residents of the locality.
No, Mala, this will also cover. Here, the specific observation that the association is espousing the cause of their members only, not for all the members of the locality. They are espousing the cause only for the members only who are personally affected. This is my case also. The members are personally affected by the act of the private respondents.
Your first line is petitioner number 1 has been constituted
My
to
lord.
look into the problems and difficulties faced by the people of the area.
Yes.
People of the area.
Area
at
means that
large.
association.
At
Only
large.
the members of the
So, if
association.
the entire area, your first line says so.
Yes, my lord.
So if the entire area is the association, it's a public interest litigation.
No, Malad, can just this
Please show me
here
the-
also, Malad, here also, Malad.
Please
Can
show
you
me
see?
the
Yes.
relevant
Malad.
paragraphs.
my lord, page 3, my lord,
Yes,
page 3, fourth paragraph.
yes.
Now, it is contended by Mr. Mojumdar that individual manufacturer may maintain the writ petition being allegedly affected by the said advisory, but the association cannot maintain unless the association suffers any prejudice or its rights are being affected. It is evident from the pleadings of the writ petition that the association is basically protecting the rights and interest of each of its members, being the manufacturer of motor vehicles. And the aim and object behind the formation of the association is to protect such interest.
This is a different issue altogether. Here, the association comprises all the residents.
Yes.
The question is not, maintainability has not been challenged on the ground that association cannot file a writ petition. That is not the issue at all. Here, the issue is whether the association could have filed it. Isn't it? Could have represented all the members.
Ma'am.
Since the individual members had not filed the writ petition.
Yes, ma'am.
Here, the issue is not that at all. This is in the nature of a public interest litigation.
Well, no. That my specific case is that the individual members are affected by the acts of the private
Who
respondents.
are the individual members? The residents of the locality.
No, the members of the association.
Please come to your writ petition. You say members are the residents of the locality. First line.
Yes.
Association can of course file a writ petition. There is no doubt about it.
Now that the petition number 1 has been constituted to look after the problems and difficulties faced by the people of the area Santipolli. This particular Santipolli is a very limited area, and all the members of the Santipolli is the are members of the association.
So doesn't that become
They
a public
all
interest?
are affected by the act of the private respondents. They are individually affected by the acts of the private respondent. Then how can you? In case of public interest list on the main ground of the public interest list, that there shall be no private interest of the person, of the litigants.
Or a private
In case-
interest of each of the public.
Yes. Here the petitioners herein are personally affected, then how can it be a public interest litigation?
I'm sorry.
This is
sir.
my question, my
This
lord.
is a public interest litigation. All the members of the petitioners are members of the public at large.
Yes, my lord.
No individual, in a public interest litigation also, individual interest is affected. Besides the entire public at large being affected.
Here,
Yes.
no, here
Here
the
it is
publics are not affected.
They are the
Here-
public. They are the members of the public.
They are the member of
The
Santipolli.
entire
This
locality.
Santipolli is a very limited area where they all are affected by the acts of the private
I'm
respondent.
sorry, sir. I'm sorry.
Not all other persons of the locality or any other area. Because they are conducting the business activities, commercial activities in a residential area.
That is on merits. That is on
That
merits.
is why they are affected. They are individually affected.
The appropriate
No,
bench
no,
will help
not a
you.
fact that other members, other area localities of the is affected.
One
So how it
single
is a public
locality-
interest litigation?
Entire public of a particular locality. This is a public interest. litigation. If it comes back to me, I'll deal with it. Not at this stage.
As your lordship.
And this is not applicable. A society has the right to file a writ petition, no dispute about it. The matter in issue involves all the residents of a particular area being Shantipolli. The issue being in the nature of a public interest litigation, comma, the matter is released due to lack of determination.
Lordship is referring it to the public interest bench
They'll
or
do it within, that's the direction of the Honorable Chief Justice. They'll do it within 24 hours.
converting it as public interest litigation. That is the your
I have
lordship.
released it on that ground. So now they'll do the needful.
Your lordship has stated that this is a public interest
Yes,
litigation,
yes,
it will go to the
yes.
public. So it will automatically be converted as public interest litigation.
The office will do the needful.
I appear for petition.
I'm for the state respondent led by Mr. Devjit Mukherjee.
It is that matter, my lord. But here, my lord, the petitioner, my lord, has my lord, the initially earlier filed a writ application, my lord, against my lord, the illegal taking over of petitioner's land at the instance of the Kolkata Municipal Corporation, my lord. That petition was dismissed. Against that, we prefer a writ appeal, my lord, where, my lord, it has been disclosed that it was taken over under section 17A of the Inland Fisheries Act, my lord. My lord, thereafter, the Honorable Division Bench granted us liberty to prefer appeal in terms of West Bengal Inland Fisheries Act before the appellate forum, my lord. Appellate forum by the impugned order, my lord, which is appearing at page 164, my lord, has dismissed the appeal, my lord, by relying upon a subsequent, my lord, the order of the BLR, my lord. Order was passed on 10 June 2022, my lord, by relying upon a report of the BLRO dated 5th August 2022, my lord. And that report also was not communicated to the petitioner. It is complete non-application of mine, my lord. My lord, kindly see my last paragraph, my lord, page 164, my lord. Asks report of the on the nature and character of the alleged place of land, premises number such and such from the DLRO, dated 30th June. Order was being passed on 10 June, my lord, and followed by dated 4th August 2022 as reminded. The same was received dated 5th August 2022, along with copies of the record of right from which it is depicted that the alleged plot of land is classified as Pukur. A 10 June order was being passed by relying upon a decision or report of the BLRO, my lord, subsequent report that was also not communicated to the petitioner, my lord, so that we could challenge that report also, my lord. Suffers for complete non-application of mine, my lord. Kindly set aside this order, my lord, and permitting to take a decision, the authorities to take decision afresh, my lord.
But it is to be so far as I do not find here the order passed by the competent authority that has not been annexed, against which, my lord, the appeal was taken out. Now the
No. 164, the impugned order, which is impugned here in
164. That is the impugned order. That is the appellate authority's order.
The entire affidavit which was filed by them, my lord. My lord.
What is the order of the appellate, the primary authority?
Page 160 is the order passed by the Honorable Division Bench.
No, not the order of the division bench. Order to say they prefer an appeal against that order. Competent authority order.
Well, that was not disclosed in their affidavit, my lord. Only from their affidavit it was disclosed that it was taken over by the authority in terms of section 7.
A copy of the order against which you have preferred this appeal.
No order. My lord,
You prefer the appeal without the order.
my lord, the Honorable Division Bench granted us liberty against that order, my lord.
Against which order?
Against the, my lord, the 17A requisition passed.
Yes, 17A order was there. Therefore, that is the reason you have preferred an appeal.
But here the 17A order was, my lord, the my lord, page 116, my lord. And 117 is the notice. Your order, you are misleading. Here, my lord, I have challenged the order of their order, but the appellate authorities order, the initial order passed by the 117 at their notice, my lord, and page under section 17A, my lord. Here, my lord, the issue is, my lord, the appellate authority has
17A order.
my lord, page 117 notice.
Notice, order.
My lord, 118 their requisition, and page 119 is their order. All their affidavit, entire affidavit has been annexed, my lord. 119 under this circumstance is recommended management of the aforesaid water body may be taken up with immediate effect by invoking 17A.
This was passed without giving you an opportunity.
My lord, no, disposed of by without giving it, my lord, report of dated, my lord, 5th August 2022, my lord. The order was passed on 10 June by relying upon a report of dated 5th August 2022, my lord.
30th June and 4th August.
My lord.
My lord,
Yes, how do you explain this?
yes, my lord. In my instruction, my lord, last occasion, my lord, I have the notification letter, my lord, 5th August of 2022, my lord. Here and now, my lord, I am serving him, my lord.
The order was passed on 10th June 2022.
Yes, my lord.
How could the authority rely on a report of 10th,
5th
4th
August.
August and 30th June
My lord.
on 10th August, on 10th June?
My lord,
fifth August কোন সালের এটা?
Order was
22.
10th June. He has relied on a 30th June and a 4th August report. How is that possible?
my lord, kindly direct the appellate authority to fresh hearing for fresh hearing, my lord.
And copy maybe this,
And-
this report maybe, my lord, served upon the, so that we could challenge.
Okay.
Yes, Mr. Ghosh?
Upon hearing both the parties.
That I find one of the 10 June order, then there is a reference of
Absolute non-application of mine.
in the 5th August and
30th June
2022.
reminder, 30th June, 4th August.
On an earlier date, the authority has relied upon these two reports.
is a subsequent melody. Or
Absurd.
My lord, fresh.
Let this be set aside and a fresh consideration. be
you should record that these are the reasons for which your lordship is demanding the matter back to the
heard learned counsels for the parties. Being aggrieved by an order of the concerned authority
5th August.
under section 17 capital A of the West Bengal Inland Fisheries Act, 1993. The petitioner approached this court for setting aside the same. A coordinate bench of this court dismissed the writ application against which the petitioner referred an appeal. Petitioners referred an appeal before an honorable division bench of this court, wherein the honorable division bench, by an order passed on 3rd December 2021 in MAT 699 of 2020, granted liberty to the petitioners to approach the appellate authority under the provisions of the West Bengal Inland Fisheries Act 1982. For redressal of their grievance. Stop. Pursuant to such direction,
Orderটা করে পাস করেছিল।
the appellate authority
এখানে 10 ফেলি
under section 18 of the West Bengal Inland Fisheries Act, 1984. And the appellate authority, by an order passed on 10th June 2022.
চিঠির সাথে কি আছে? চিঠির সাথে কি আছে?
Learn down.
ও
Dismiss the appeal. Dismiss the appeal. Upon placing reliance on reports submitted by the District Land and Land Reforms Officer, South 24 Parganas on 30th June 2022. No, on 5th August 2022. 30th July, 5th August 2022. Stop.
These are forwarding letters.
These are the letters that
Forwarding letters.
received on
5th August.
2022. Yes. Paragraph.
Report, in fact, now the record of rights has been forwarded. Copy of the record of rights have been forwarded.
Strangely, comma, the order impugned was passed on 10th June 2022, relying upon a report which was submitted on a subsequent date, comma, that is, comma, 5th August 2022. Hmm. This indicates absolute non-application of mind by the concerned authority in considering the appeal preferred by the petitioners. Paragraph in view of the above, the order impugned dated 10th June 2022 is set aside. Paragraph, the concerned authority being the
Respondent 6, my lord.
sixth respondent hearing, comma, is directed to reconsider the appeal preferred by the petitioners upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. Within within 1 month.
1 month ago,
My lord.
Yes.
It will be 2 months, my lord. That
Within 2 months from the date of communication of this order.
Your should make it clear that your has not got into the merit on the issue of the merit.
Yes, in accordance with law, that is what I
Yes.
stated. A paragraph, the concerned authority shall make over a copy of the report of the Block Land and Land Reforms Officer, South 24 Parganas, dated 5th August 2022, to the petitioners prior to commencement of hearing of their.
in course of the day, I will serve him,
I
my
have to
lord.
commence for the hearing. Hearing and I delay.
If she wants to serve in course of the day.
Yes, my lord.
There's a difficult.
I have the copy, my lord.
But he will serve it, then he will not keep it with you.
Advice should be good advice.
Yes.
Next.
That I appear for the respondent authority.
for the Kolkata Municipal Corporation.
My lord may look into my lord's previous order.
Policy decision of the
Yes, yes,
KMDA.
yes, yes, yes. I was directed to take instruction on that because filing a supplementary affidavit, Lordship will find that one order was annexed, order passed by the authority. If your Lordship takes up the supplementary affidavit, then I am furnishing.
Yes.
Last annexure, Lordship will find this is the order ultimately passed by the authority, having regard to his claim. the penultimate paragraph, hence the petition is disposed of ex parte. It is an admitted fact. The later on, my lord, the hearing was not attended. He also says in his supplementary affidavit, ex parte with the direction that the petitioner may avail the facility to get NOC for the period as extended by KMDA board for all EWS, LIG and MIG category by meeting dated 26th April 2022 on further and fresh application to this authority. Lordship will find the signatory, that senior deputy secretary. This order was passed. So my learned friend questioned that what is the decision on 26th?
And it was your submission that a policy
Yes,
decision was
policy
taken by the authority on that day.
I have got that policy, my lord. I have also supplied my learned friend a copy.
My lord, they ratify, my lord, they say, my lord, as apprised by my learned senior friend. My lord, they have taken a decision to extend for 3 years, my lord, to complete the construction. And my lord, that has been ratified by the Deputy Secretary Estate Unit KMDA.
Lordship will
Respondent
kindly
number 4.
excuse me. There is a marking. Lordship will kindly excuse. This is the decision. This is the concluding portion. It starts from the previous page. Lordship mark portion. Lordship will kindly excuse me. This is the decision taken by the Land and Flat Allotment Committee of the KMDA. And later on, it was ratified by the board. This is here. Ratified on 26th April. That is why the decision is referred to as 26th April. Lordship will find from that page 1. This refers to the decision, the earlier one I placed.
This is the 26th April decision.
26th board ratified that. So the decision became the decision dated 26th April. That is why this 26th April was mentioned.
What is your prayer?
Your prayer is to, my lord, grant the NOC, my lord. As per, my lord, the previous order passed by my lord, we made a representation before the, my lord, Deputy Secretary MM. My lord, Deputy Secretary MM, my lord, was pleased to observe, my lord, I have to apply before the appropriate authority. My lord, and that was forwarded to Senior Deputy Secretary MM KMDA. My lord, who reached to the conclusion as per the decision, my lord, of 26th April, which is there on, my lord, reckoned by way of a supplementary affidavit. I am entitled to get NOC. My lord, that decision was called for by my lord, and my lord, the question cropped up, my lord. He was asking me going to the authority, my lord, before the Deputy Secretary. My lord, I say, my lord, Senior Deputy Secretary has taken a decision that I am entitled to. And my lord, my initial representation pursuant to my lord's direction was before the Deputy Secretary. My lord, therefore, my lord, instead of again getting things rolled once again in a fresh manner, if the policy decision is already there and I am entitled to, my lord, even without paying any penalty charges, as my lord has seen, my lord, then my lord, NOC may be granted. And my lord, after NOC, my lord, on sanctioning, because my lord, my construction has been stopped because the Kolkata Municipal Corporation, my lord, is not sanctioning my plan because there is no NOC from the authority.
Lordship,
So, my lord, if I get the NOC,
Lordship kindly sees the order passed in pursuant to your lordship's order. That is annexed in the writ petition, the last annexed, and in my copy, there is no pagination.
page 56.
After
Last
but
last.
last is 10th August order, and before that 13/6.
Yes, yes.
13/6. This is the order was passed pursuant to your lordship's
Page 57.
direction.
6 years.
Yes, lordship, if you lordship kindly turn to the third page. The allotment was otherwise liable for cancellation, but since the allotee falls under the rehabilitation category, so it was observed.
She will submit a prayer before the KMDA authority seeking relief. My lord, the authority I find, my lord, from this policy decision is the Deputy Secretary MM. My lord, my lord, the letter, my lord, of the policy decision of my lord,
Concluding
26th of
paragraph,
April.
my lord will find. Accordingly, the matter was placed before the board, and the board took decision that Deputy Secretary himself should take a decision. if your lordship kindly sees the written instruction I have received, lordship, that part will be clear. If your lordship kindly have it. This is my written instruction.
Yes, Lord, I
Why
agree.
it was again,
Lord, I agree. Lord, if deputy secretary is the authority and senior deputy secretary is saying, Lord, I'm entitled to NOC. Lord, and the policy decision also allows me an NOC for a further period of 3 years. Lord, this order, Lord, which is appearing at page 57, Lord, passed by the deputy secretary. This was passed upon my representation made before the authority to grant NOC. Lord, then this authority, Lord, setting aside, my Lord, my direct, Lord, I'm entitled to NOC, and Lord, this authority, deputy secretary will only issue now, my Lord, an NOC pursuant to my Lord's direction. Lord, no further fresh consideration is required.
paragraph 10 onwards, lordship kindly have.
Over.
Lordship, this
Over.
instruction contains the narration of entire facts. Lordship 10 onwards, lordship kindly have a look. This will reflect the entire picture. 10 onwards.
কোনটার গো?
Yeah, wait a minute.
Oh, এটা তোমার instruction.
You know, go through it.
না, 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 ঠিক আছে।
Facts টাই আমি বলছি।
The competent authority is the board.
Board again directed the deputy that it should be decided by the deputy secretary himself. That is why a fresh notice was given, which was annexed, notices annexed in the supplementary affidavit. But the petitioner chose not to appear, and the expertise decision was taken. Expertise decision, of course, it did not go against my learned client. But this is the fact.
Actually, there is no dispute.
No, there is no dispute. There is no dispute.
May I
These
take
are
your,
only technical.
Technical, my Lord.
my junior, may I take your lordship's leave, my junior?
You are appearing for whom?
Games.
Games. The state is not appearing in this one.
The state is
Yes.
not necessary, my Lord.
It is not a party.
Party, it's not a party.
You write it
KMC will be a party.
KMC would be a necessary because
KMC ka no.
the NOC will be given to KMC.
It is not been granted. So in terms of your this, let the NOC be granted. There is nothing further left in this writ petition.
As per the instruction and the policy I have referred.
Yes.
Lordship will consider the supplementary, the order
Well, may I just take your lordship's leave, my lord, my junior?
which is annexed in the supplementary affidavit 20th February, order and kindly consider, and the 20th February 2023.
Yes.
I should consider that, having regard to the policy I have placed before your lordship. I have placed this policy decision because this has been referred to in the 20th February order.
So now who should be the authority?
Deputy Secretary, my Lord, as per
The deputy
Number 4.
respondent number 4. Who shall issue the NOC, my Lord?
Yes, my lord, as per 20th February order, senior deputy secretary would be the authority.
Senior Deputy Secretary.
Senior deputy secretary, because the order says so.
Action
This was directed by the senior deputy secretary.
Senior, and
Look, I have no problem if senior gives or junior gives.
Doesn't
So
make
now
any
it's
difference.
granted. You are right.
I have no issue.
Lordship, keep that option. Respondent, senior deputy secretary is not the party here. Or the,
I can add him because the authority is same.
or the
KMD.
officer competent to take decision. Then
I
the
can,
problem will be.
I can add him here and now.
So let's.
But order says, order,
Be added.
order says, or the 20th February order, last line, this authority. And the
Let him
signatory
be
is
added as a respondent
My Lord, my learned friend is already representing the authority.
on prayer of the
Senior Deputy Secretary.
petitioner. The senior deputy secretary hyphen Roman 1, comma, estate within bracket MM, bracket closed, MM, bracket closed, unit, comma, KMDA, be implemented as respondent number 7 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly.
ঠিক করে দিচ্ছি। আজকেই করে দিও।
It is contended on behalf of the petitioner that as compensation in lieu of acquisition of the land belonging to the petitioner by the KMDA, the authority executed a deed of lease
Senior Deputy Secretary. Senior Deputy Secretary 1,
Per labor.
Estate Unit KMD.
You know, Lordship's earlier order dated 8th February recorded the entire. 8th February, yes. That is
Page 47.
Page
The entire fact is recorded.
entire fact.
by virtue of a deed of lease executed on 15th March 2001 for her rehabilitation. Stop. The petitioner constructed a boundary wall in the plot and the plot was mutated in her name on 4th April 2013, following which she applied for sanction of building plan in order to raise construction in the said plot in terms of the deed. The executive engineer within bracket building bracket closed KMC made, this is an earlier petition,
Yes,
Earlier
madam,
it-
this is second
This is
round.
Second petition.
made several communications to the KMDA for grant of no objection in order to enable the authority to process sanction of building plan in favor of the petitioner. Stop. Since such no objection was not provided by the KMDA, the petitioner submitted a representation before the concerned authority in this regard. Which also not being considered, the petitioner approached this court by way of a writ petition, praying for consideration of the same by the authority. Stop. By an order passed on 8th February 2022 in WPA 19546 of 2021, this court directed the concerned authority to consider and dispose of the representation submitted by the petitioner within a stipulated time frame. Stop. Pursuant to the said order,
That is last
the
annex.
petitioner submitted a comprehensive representation before the concerned authority on 18th February 2022. Which was considered and disposed of by the Deputy Secretary, Estate within bracket bracket closed unit, KMDA, by an order passed on 13th June 2022, which records that since the petitioner fell under the rehabilitation category, comma, she could submit a prayer before the KMDA authority seeking relief. A prayer was made after this?
My lord, after this, my
Prayer
lord,
was made after this?
my lord, after this, my lord, the
Lordship,
senior
Lordship
deputy
will-
secretary, my lord, issued a notice to appear, my lord, takes my kindly takes up the supplementary affidavit. To be present, my lord, before him, my lord, on such and such date, and my lord, pursuant to that, an order dated 20th February 2023 was passed, where, my lord, as per the policy decision as produced by my lord,
Subsequently,
Lordship will kindly record that that 13th June order, that the allotment was otherwise liable for cancellation, but
You need the
since
detailed record.
she falls
it
under
is
the
not
KMDA
required, my lord.
But the
Unless
formal
it-
check, Lordship can record that.
But after, my lord, the policy decision comes, my lord, it's
it's not
makes.
required, not relevant.
I'm sorry.
And the order is there on record. Subsequently, a notice of hearing was issued to the petitioner by the senior deputy secretary on 15th February 2023. And a hearing was conducted on 20th February.
Yes.
Petitioner did not appear.
My lord, did not appear, but it was suo moto order passed, my lord, I'm entitled to.
The petitioner did not appear before the authority in terms of the said notice, comma. A hearing was conducted by the authority on 20th February 2023 and an order passed on the same date. The order demonstrates that the petition has been disposed of ex parte with a direction that the petitioner may avail the facility to get NOC for the period as extended by the KMDA board in its meeting held on 26th April 2022 upon fresh application to the authority. Stop. Paragraph, learned counsel for the KMDA places reliance on the policy decision of the authority taken on
26th
26th April
2020.
2022. Stop. The relevant portion of the decision is set out. Decision decision the committee reviewed a meeting for ratification. The said decision was ratified by the
KMDA board
KMDA board.
KMDA board
in its 192nd meeting, authority meeting,
by a resolution taken in its 192nd meeting. Stop.
held on 26th.
Paragraph
Held on 26th April. That is why this
held on 26th April 2022. Paragraph. In view of the same, comma, the petitioner seeks a direction upon the concerned authority, being the
Senior superintendent respondent number
second
7.
respondent
Seven.
herein to issue NOC in favor of the petitioner in terms of the policy decision of the authority taken on 26th April 2022. Paragraph, upon consideration of the submission made on behalf of the parties and material on record, comma, this court is inclined to hold that in view of the policy decision of the authority dated 26th April 2022, comma, the sixth respondent,
Seven.
seventh respondent be directed to issue NOC in favor of the petitioner. Hearing is required.
No, my lord, no further.
Within 1 month
Lordship.
or a shorter date. Let it be 2 weeks.
Oh,
Let it-
let it be 2 months because of election, the officers are.
MD officers also election.
Yes, many officers, so many officers are.
6 weeks.
Let
Within
it,
6
let it be
weeks?
8 weeks so that.
Very good. Within 8 weeks from the date of communication of this order.
My lord, to cut short future litigation, my lord, may I just humbly request my lord to indicate, my lord, the period of 3 years to be reckoned. My lord, from the date, my lord, I place the KMC authority with NOC and they issue a sanction plan. So unless, my lord, they issue a NOC, I cannot get a sanction plan. I cannot make construction within 3 years extended period. My lord, otherwise, this will cause a future litigation. This should be end of all litigations.
What do they say?
Decision says, my lord, there
3 years extension,
3 years extension.
but 3 years to be reckoned, my lord, from the
And
date.
commence from the date of
Date
grant
of
of NOC.
granting, date of
Date of grant of
granting,
NOC.
it should be.
My lord, otherwise I
The-
give an NOC to
Definitely
KMC.
accurate. The period of 3 years
That
as
says, itself says.
recorded in the
Granted,
policy
granted
decision
থেকেই তো হবে।
shall commence from the date of grant of NOC by the authority.
That is of course.
This was not conjecture.
Below the written instruction, including the policy,
Written instructions
let it be.
ekdam shuru pe. Submitted on written instructions as well as the policy decision submitted on behalf of the KMD are taken on record.
Much okay.
Next.
লিভ দিয়েছে পার্টি অ্যাড করতে হবে
Yes.
I am, only one thing, my lord. Because they produce the record, my lord. It is their own document. If it is the son is stillborn, my lord, they can.
Please make your submission with regard to jurisdiction of this court. Because even no part of the cause of action is also within the territory of, within this state.
So, my lord, they feel they
How
argue.
does this court have jurisdiction to deal with the petition?
Sir, jurisdiction, court both jurisdiction are court satisfied. What is the jurisdiction?
That's the preliminary issue.
Jurisdiction regarding, my lord, whether infringement of the rights.
Territorial jurisdiction.
My right, case is admittedly case is pending.
Territorial jurisdiction.
My lord, that
How
is,
does the writ petition
I
lie
am
before
placing,
this?
my lord, the
Because the entire issue is.
entire case is,
nuisance.
if any part of cause of action.
Where is that part of cause of action?
Yes, ma'am, there is a part of cause of action as soon as the notification issued by the government of Assam, having knowledge the case is pending in the High Court. That right by my section 52 has been infringed. As soon as the notification is issued, having knowledge the case is pending. That right is infringed. If I go to the original side, my lord, they will have given jurisdiction. Why the appellate court will not have the article 226? Your lordship will not enter into this case. That is a pure and infringement to my right.
Very well.
It is a theory, my lord. That is why, my lord, if the infringement of right relates to the relief for which I have come before your lordship, then jurisdiction will come. That is the my office chamber case, the 2006 case. I will rely on. And my submission is that, my lord, so far as they are good, my lord, they started the proceeding. Already they started the proceeding under Central Act, my lord. Board was constituted, meeting was constituted. They did not disclose any reason till now by these evidence why they did not follow that. Why they abandoned it on the halfway. We have no objection for education, my lord. They can, but they should proceed according to the law. If,
You are only on compensation as a co-sharer.
yeah,
That is your case.
my
Primary.
case is, my lord, they should follow the procedure. Because what they did before, when I came to learn that they are going to do something and they are trying to give the land to the government, my lord, I made the representations before passing of the decision of the government. That order, my lord, 21-1, that has been suppressed by them. We have produced the distinguished, my lord, he received it. His office acted on it. That representations.
Where is your representation?
Is
Is it annexed to the writ petition?
no, petition, yeah, our petition, my lord, section page, lecture P. The writ.
Annexed to the writ petition?
না না রিপোর্ট না আমরা যে পিটিশন করলাম মৌসুমী মৌসুমী ওই যে 21 I'm giving notification 21. Yes, my page 76 of the writ petition, my 20th day of October 2021.
Yes.
That is, my lord, before starting the action. Bona fide, they should show the bona fide. They have no, government has no power to overrule the provisions of the law.
So this has not been considered, you say?
No, consider, they suppressed it. Rather than the report, they stated that did not receive it.
No, I'm
But
sorry.
record shows that we have.
I will correct my friend. It has been dealt with in the report that has been filed.
No, dealt with is subsequent.
Anyway, you
one.
make your submissions, I will show it.
Dealt with subsequent one, my lord, after acquisition. Because payment, before award of the payment, I applied to them. You are taking the land, kindly give me the paper. Under right of information, my lord. They suppress all facts. They give only 2 papers. Now that has come before your lordship from their own actions. That are the actions taken by us by concealment. It is the concealment of the everything. If the government can come with a show that for that reasons we are unable to perform the duties as alleged by the law. Your lordship no hand until they can satisfy your lordship. If we are unable to perform our duties specified by the laws.
What is the duty specified?
That is the duty that Central Act has stated, my lord. There should be publication. There should be direction. There should be all. These are the central duties that is the inbuilt right to me.
The 2013 Act?
Yes.
It's 20. Section 5.
Section. That is from 5.5, my lord. That on 2 principles, your lord, my lord, on 2 principles that would be may be considered, my lord. That not only the obligation, that is an inbuilt right given to the citizens.
Section 5.
Yes,
Section 5.
Section?
Section 5 of the Act.
Section 5. Section 5.
Public hearing on social impact assessment.
So before you proceed, shall I release the other matters for the day? Because I think this will take some time.
I guess so, madam.
Chidi, other matters released for the day. First of matters, group 1 matters.
Yes, ma'am.
This will take some
Well, the next matter, my lord, is very short, my lord.
Please come back next day tomorrow. This will take
Tomorrow,
some time.
tomorrow.
This will take some
Second of my lord will not be taken.
time. Second of group 7 matters. Group 1 will not be continued in the second. Yes. Section 5.
Section 5, my lord. These are the not only duties, my lord. That also give the rights to the citizen, inbuilt right, protection, safeguards given to the citizens to prevent the unfair actions of the authorities. Why legislature imported all these things, my lord, in the right to fair complaint. Section 5.13. This is the your lordship consideration. 5, the public hearing for social impact assessment. That should be done first. But the publication, what is the publication? Under section 6. Very simple matter, my lord, only question of law and touching the jurisdiction of the authority. Fairness, dishonesty of the government.
A social impact assessment study has to be undertaken first.
Easy.
If it is found that there is a social impact, then only section 5 comes into operation, isn't it?
Under the act, we can file the objections. Instead of, my lord, without knowing, we have some apprehension in the mind. This party, respondent, private respondent, in order to deprive us, they are incollectively, they are going to the government to do something or other parties. And we met the district magistrate and we submitted the petition. My lord, that petition, your lordship, they kindly, the subsequent 2 petitions, my lord. First petition, my lord, page 76, 5 petitions.
52 also.
First petition, exhibit P3, page 76.
Right.
My
Yes.
lord. Here I have honor to state that reliable source. I came to know that Prabir Kumar Bora, my respondent, my 811, and Red Kumar Bora and others have proceeded to sell out or surrender the land and palace known as Hukwa, that is my Matiabag Palace, my lord. Situated Matibag, Goriabag, owned and possessed by the late Raja Prabhat Chandra Bora of, this is my lord, joint property, ancestral joint property. The ancestral joint property right, my lord, person, all are again. So, for partitioning the entire properties, both movable, immovable, including royal guest house, Hakana, situated Gauripur, left Raja Prabhat Chandra Bora, a partition suit filed by Administration 1993 still pending before the Honorable High Court, where a preliminary degree was passed. Appointment Mr. Pratul Chandra Das as commissioner to the effect the partitions of the shares among the legal heirs and successors of the late Raja Prabhat Chandra Bora bound and meets as per preliminary degree. Accordingly, 28/5 Commissioner of Pratul Chandra Bora submitted the commission report about the Matiabag Palace surrounding the Khotian number. This is the Khotian number, most important one. Shall be divided among the Kumar Pritish Kumar Chandra, heirs of the Pravanesh Chandra Bora and Alokesh Chandra Bora, Shamalesh Chandra. They are the uncle and Arup Kumar, the petitioner's father. Arup Kumar Bora. And Shamalesh are the uncle. So, my lord, all the Prabhupada Chandra Bora and they play special, but till date, neither special referee is appointed to this effect nor final degrees passed. And prepared by the Honorable High Court, the matter is still sub judice in the court of law. Section 52, how the government will overlook, my lord? Is it on the part of the bona fide on the benevolent government?
Section 52 is not a bar.
Yes.
Section 52 is not a bar.
Yes.
Section 52, do you have the
Section 52 restriction, my lord.
Section 52 says that if there is any sale, any transaction during pendency of a suit, the sale, the result, it will abide by the result of the suit.
Correct. Result will be binding by this partition.
Whoever purchases the property will be bound by the result of the suit.
That is the latest, my lord. Supreme Court elaborated this point, my lord. First they stated they cannot. Now they have come with, if any party.
The statute itself says so.
Now if any.
Transfer of property.
No, no, this is settled.
Transfer of property.
This is a settled position of law, section 52.
Statute itself says.
That's right. I mean,
Section 52.
Transfer of property.
And my lord, section 54, 55, TP Act, because buyers and their liability, sellers liability is there. These are the protection to be bona fide.
Yes, I have seen that. Oh, it's become.
ওটা ডাবল ট্যাপ করে দিন খুলে যাবে আবার
Again.
Lordship will just double tap it, it'll open.
Section 52, transfer of property pending suit relating thereto. During the pendency, in any court having authority within the limits of India, excluding the state of Jammu and Kashmir, established beyond such limit, central government or any suit proceeding which is not convincing, and which any right or immoral property is directly and specifically in question, property cannot be transferred, otherwise dealt with. Any party to the suit of the proceeding, any party to the suit of the procedure. He is not, they are not a government, has not, but Prajipura is not a third party, my. They are the party to the suit. Respondent number 4 to 30, 8 to 30. Here. Cannot be transferred, which may then accept under authority of the court or such term as may impose. I am confined to that, my lord. And subsequently, court, my lord, the Supreme Court has come to a decision on that point, my lord. If third party, if purchase the property, what would happen? Their lordship said, though he will not get the benefit of the deed. He will get the benefit of it on the decision of the case. That is the law. Here the case is different, my lord.
That is exactly what fell from your lordship, that there is no complete bar.
No.
It is voidable. That's what I said the last time.
Let me, court allows me to say something.
Court has told you the same thing, sir, what I am
I
saying.
am telling you.
Anyway, go ahead. Please continue. No
So,
problem.
court, my lord, here they are Pradipura and others, they are the parties to the suit. They have no right, according to their stream. So any act contrary to the law done by them, it is illegal, my lord. Second thing, by government, you treat that he is a third party, my lord. But third party has got knowledge of that from that, my lord. So what is the duty of the government, my lord? Under Section B, Transfer Property Act, buyers and liability. They should inquire about the title, whether any dispute is not. What is the inquiry in that matter? Has there been publication under Section 5, my lord?
Your representation says
Yes.
you have handed over a copy of the commissioner's report to the government.
Yes, my lord. Yes,
What
my
is the
lord.
representation?
We have submitted. Commissioner report is not final, my lord. Commissioner report is incomplete. We have already filed, court also granted permission, original court, my lord, last week. What are the properties are not partitioned.
Have you
But-
filed any objection to the commissioner's report?
Yes, my lord. Yes, my lord.
No.
We are
No,
granted.
nothing has been filed.
My lord, last date was there. Then we raised the point. The commissioner's report is not final. There are
Because
commissioner
commissioner
himself saying.
says that this Matiabak Palace is not within your share.
Hey,
That's right.
I've seen commissioner's report.
Yes.
no, my lord.
Have you filed any objection against that?
Yes, my lord.
No.
Your
When is the
lordship,
copy
your
of the
lordship
objection?
kindly
Can you
see
please file it?
the partition of the property, my lord. 75 bighas of the Matiabag Palace involved in the partition, sir. We should not be confused with that.
Including
I mean, that property is a part of the parcels of the 75.
Yes, but the commissioner's report shows that it has been allotted to the other legal.
No,
entities.
my lord,
right.
that a part was
right.
given to me. No, my 65 of the.
No, my lord, here
your
is where I
lordship
join
will
issue.
Let us
Commissioner,
come to the report. Let us
yeah,
come to
yeah,
the-
your lordship will kindly see the commissioner report.
Yes, open the commissioner's report.
It is annexed to your- with your.
Oh, we did.
It is not in the
Not in the.
writ petition in entirety. This is the point that I have taken. And what has, I'll show you. It is in the report of the,
Proposition.
it's in the state's affidavit, my lord.
That is on record. You filed it.
Yes, it's on record.
They have filed there. They cannot say now, my lord. We are not, because your lordship,
Oh,
It
it's
will-
a thick report.
It will be
right.
the bulky one, my lord.
your lordship will consider where the people of Assam will remain under mercy of the discrimination.
It's not a question of people of Assam, I'm sorry. He may make a short statement.
My lord.
Just confine
We are telling.
ourselves-
We are not concerned with the state of,
No, yes,
we're
my
not
lord.
concerned.
He
No,
is
I'm
the
sorry.
functionary, my.
We are not concerned with the people of Assam.
Don't disturb me. Under Article 12 of
No,
the
you make
Constitution.
some submissions
Let
and I
us
will not,
come to the
what
report.
no,
Yes.
what is this? Can you
You
take
are
page
telling
89, my lord?
discriminatory. We are telling the function of the district.
State of Assam, I'm not concerned with.
Honestly,
I'm not concerned with the state of Assam.
secretly.
He makes some submissions and I'm not supposed to object.
Cases that they were granted undue unjust benefit
No,
to the party.
Please come to the report of the commissioner.
yes, and please show.
Your share in the
Yes.
Matiabak Palace in the report.
This will end the matter here and now.
It is at page 89.
Yes, my lord. Page, kindly. Page-
Come.
Page
Wait,
Page 132.
don't jump.
My 130.
You'll have your turn. You'll have-
It is page
Let me make my submissions. You said yours.
Page
Final settlement, your lordship says the 132.
All right.
Commission
of the report,
of government, sir.
page 132.
132. Commission report that it is a settlement between the parties. Ask your lordship will kindly see, cause here, it is a part, here, page 127 of the report. Page 127.
127.
Yes, sir, page 127. See the para 3, my.
Yes.
Middle, para 3. Matiabad Palace at Gauripu with adjoining buildings with land comprising an area of 78 bigger 70 letters, and said property has been recorded in the last cadastral survey operation on the following Khutians in Moja, Gauripu town, and police station and sub-station. That is the Khutian number. Our Khutian number is mentioned, my lord. Then your lordship 132.
Yes.
132.
Kindly take 131 before that. Kindly take 131. This is the selective,
There are various Khutian, but the
selective pages are being shown.
You'll have your turn, sir.
Very well.
KDM Matia Palace and compound. In bottom, my your lordship, that is 132. Part 3. See, my lord. Partitions of the Rajbati, a compound and Matia Palace. Compound allotted to Alokesh Chandra Bora, Shamaresh Chandra Bora, Uru Kumar Bora. That is the person allotted.
Now let him show the Khatia number and Dag number in this part.
Your lordship, come to the Matia Palace and compound. Bottom.
And you derive your title from?
I will derived from the 563, 366, 365.
No,
We
no,
are
the person, your predecessor.
Arup Kumar Bora.
Arup Kumar Borua.
We are the daughter of Arup Kumar. Petitioner is the daughter of Arup Kumar Bora.
Milord, I must interject here.
Why are you interfering?
I am asking the leave of the court, sir. Please keep quiet.
No. That is
If the court gives me the leave, I'm entitled to make my submissions, not you.
A family tree was given, isn't it?
Yes, Milord, it has been given.
Family stream was the deceptive one.
Oh,
So
even the family tree is deceptive. Everything is deceptive as far as I'm concerned.
But come with clean hand.
Why don't you file and submit a
You
family
file?
tree?
Hey, family sticker.
The family tree to show your
Yes, my lord.
title.
There are some omissions.
Mhm. As far as I'm concerned, everything is deceptive.
Everything is a come.
That's the rule, sir.
It is, of course. He's entitled to plead his case. No,
Be contested. Please wait for your turn.
very well.
So that property is there also. These are the subject matter of partition. That is the 77. 77.
So you derive title from Promothesh Borua's branch.
Yes, yes.
And the other branch is Prokritish Borua and
There are two
Pronovesh. These are the three brothers.
The properties.
Three brothers.
Three sons and two daughters. Nihariwala and Bhuti. Original Maharaj.
Milord, both the parties in this contesting suit.
Ancestral joint Hindu property. It is under partition, subjudice and the partition. So all are contesting.
Matia Bagh has been given to the heirs of Pronobesh and Prokritish.
That's right.
Please,
given to.
from the report,
Correct.
show me that any portion of Matia Bagh has been allotted to the heirs of Promotesh, the branch of Promotesh. 132.
Kindly see what has been given.
Portions of Rajbati and Matia Bagh
You are diverting.
allotted to Alokesh
That's what you are
and
doing.
Shamulesh. Alokesh, Shamulesh are
My lord, may I make a suggestion? Your lordship would rather look into the Dag numbers and Khautiya numbers. That is the crux. One area of 75 bighas is split up into 3 parts in the Khautiya number and Dag number.
that comes later.
Correct.
Overall picture, I have to find out whether Omolbala Borua's lineage comes in.
Yes, they're there. There is no dispute as far as that is concerned.
Arup Kumar
My learned
Borua,
friend's client and my clients are all from the same branch of Promotesh and
the three
that
brothers.
3 brothers.
But this has been distributed among the 3 brothers.
Correct. And how it has subsequently flown down the line, that has not been shown.
That is
That is what is not being shown.
is that out.
That is not what is being shown. That's what I'm saying.
Again, my lord, my lord, point is very clear, my. If the partition final degree, admittedly, my lord, there is no dispute in this case. Till today, final degree has not been passed. If the final degree is not passed, this preliminary degree cannot take legal effect. It is not a degree at all in the item.
That's the law. That's the law.
The Supreme Court has said, my lord, regarding preliminary degree, nobody can take advantage from preliminary degree until a partition is. Even position was given.
That I will deal with this issue.
Do you agree to this?
I have not seen that. I have not seen that as yet. I have not seen that as yet, but I presume it should be correct. I hope it is correct.
Please find this, check this.
I will certainly check it.
Today, I'm sorry, we are running short of time, so we have to come back some other day. I'm sorry, sir. Troubling you every time.
Despite lots of order, matter is not come on the top of the list.
I'll ensure that because
Another indulgence that I seek.
the matter will take the whole day in that. That is the difficulty.
It actually will, my lord, because there are so many documents which I have to show which have not been shown.
The other cases suffer.
I understand.
12:30.
My lord, it will take longer. It will take longer, my lord.
I know, but I cannot complete it in a day.
Very well, very well.
This code deals with a list of you've seen. I mean,
Then, my lord, may
150, 200 matters. So
at noon is
it will take time. Yes, it will take time.
It will take some time.
your lordship can keep it at noon. It's a,
Make a specific submission. I would request you to make a specific submission on the next date.
I will give the written, my one written.
Your how this has been conferred on you, the title. Yes, because you
let him
belong to
prepare. Let him prepare a
Promotesh
flow
House
chart.
lineage.
I will not.
That is not necessary. I would just like to have a clear picture of
Yes,
it.
Miller, what has fallen from your lordship?
Admittedly, all of your co-sharers.
Of the
Branches are to be identified.
no, we are co-sharers of the original plot of land of 75 bighas. What has fallen from your lordship is let him show a flow chart as to from that 75 who gets what. That will end the matter.
My submission is they should show before final degree they can do anything regarding.
I will show that. I will
Yes,
show that.
show.
I've got an authority on
I
that.
will show 91 Supreme Court.
I will show
Position was given.
I will show, my lord, I will show 2003 Supreme Court.
Position
That is one aspect.
partition must be complete.
That is one aspect.
Yes.
The other aspect is Matiabag Palace or any portion thereof has been allotted
Yes,
to
my
you
lord.
by the commissioner.
That is prime issue.
It has not come to my eyes. I have.
That's
not read
right.
the report.
That is right.
Come back with that.
Yeah.
My lord, may I make one indulgence in the last occasion? I think there was actually an omission on our side. That they have withdrawn can 2. My lord, that has not gone out in the order. That should be recorded, my lord.
That has been recorded.
No, it hasn't gone down in the last order, my lord.
Production of the record.
So your lordship may kindly record that
Amendment and yes.
Can 2 shall be withdrawn?
My lord, and as far.
2023 Act order code, before I forget, let me pass.
Yes,
it.
my lord.
Can tutor code, learned counsel for the applicants / petitioners seeks to withdraw the application. Paragraph in view of the same, can 2 of you is dismissed as withdrawn.
My lord, as far as can 1 is concerned, your lordship had observed.
Not an urgent hearing.
That's right. So there is nothing in that. So that can also be disposed of. There is nothing in that application.
What is not available? Your lordship, kindly see my.
Kindly see, kindly show.
See?
Can 1 is only for an early.
Yes,
hearing.
kindly show.
No.
The time you're riding horses, please show.
No. See, you see the prayer.
Please see the prayer in can 1.
Petition for you is clear, your lordship.
We are talking of can 1, sir.
Can 1.
We are
Can
talking
1.
of can 1. We're not talking of the repetition.
Can one, my lord. That
Can
is,
1 is for early hearing.
That's
so
right.
it will also be disposed of.
That's right.
dispose, my lord.
Correct.
There was the effect that the matter will be disposed of.
No, my lord. I'm sorry, my lord. That can't happen. That can't happen. Your pleadings may say something and your prayer says something else.
Prayer, my lord, that is right.
When do you intend to come back? Heard learned counsels for the parties. Paragraph.
My lord, subject to my learned friend's availability,
Paragraph, let the matter appear under the same heading for further consideration.
subject to my learned friend's, my lord.
Yes. So this month it will not be possible.
No, not this month, my lord. Today we are already on 27th July.
July.
If you're on 27th today. My lord, because I will also have difficulty till 22nd.
26th. Because he comes from Assam, so we should accommodate.
26th is fine, my lord.
20. Fine. So 26th.
26 at 12 o'clock by now, 12:30 by now.
12:30.
Will be filing.
Happens, we are every time embarrassing you by seeking and on the top of the. Direct them to at least put it.
They probably have a difficulty, my lord, explaining to their superiors on this.
Let it be on at 12 on Monday. Let us see what happens.
Very well.
26 July at 12 noon.
And I am bringing on, my lord, as per our case 29, 2 order may be provided, notification, which was published on 12/1/2022. That notification has been attached here.
I'll hear you on the next day, sir.
Yes, that was not attached here. That may be produced, my lord. It is a vital notification, my. 12/1/22.
What is that notification?
I
Has not been produced, your lordship.
notification.
Report of the circle officer and notification issued by the government constituting the purchasing committee. That committee overlooked.
It's on record. It's on record in their, yes, in their documents.
Act on the same subject matter.
When the council says
It's on record.
It will take time, my lord, because how the 2 committee will function at the same time.
Please tell him the page number.
Yeah.
Please help him out with the page numbers because he's not aware.
My lord, then I presume on the next day, I will not make submissions. My learned friend will make his submissions and conclude it. Thereafter, I will make my submissions. So let him not stand up sporadically. When I am ready to argue my matter, he stands up today.
15 minutes, so you'll be able to complete by then.
15 minutes, but I will, my lord, will only give on a written with short notes.
That comes later. If
Yes.
it's,
Lillian.
Yes.
My lord, more than lineage, what is required is what fell from your lordship is the flow as to how he has got the title. That is important. That is more important than the lineage, who is where. Let him show that.
Not who's fair, how they've derived titles.
That's
That is
right.
important.
That is right.
And whether any part of it has been allotted in your favor by the commission.
By the commissioner's report. That's right.
Since you have not filed any objection against the commissioner's report, as I have been given to understand.
The original report is of the commissioner is of 1977, and in the meantime, the commissioner is also passed. So we have chosen to do another report from the original side suit, the partition suit, that is not the time to speak. But we will give that. We do not intend to open that up here.
No, that's fine, but then it is for that court to deal with the.
Correct.
actual-
Absolutely.
I do not know how far the writ court.
Yes,
can
my
reach.
lord.
Cannot.
Yes, my lord.
Depending on
Your
the
lordship will
That is the
confine.
reason
Refresh as on date to make.
Very well. That's, so in the meantime, you will take necessary steps
That is.
and please come back with an order, if any, passed by the party.
Only I am legal effect of the actions.
Very well.
Obliged.
situation, may I permitted to mention it? Your lordship kindly remember, your lordship heard the matter on 23rd, a contempt application. And due to affidavit service was not ready. So your lordship please to fix the matter today. But in the order sheet, it was recorded as 27th July.
Please come back at the mentioning time, serve the other side and consider.
My lord, other side was not appeared in this matter.
Please come back at the time of mentioning, sir. This is not the time.
My lord, I am leaded by Mr. Mukherjee.
Raise this, please.
My lord, I am leaded by
130. 129 of the motion. 129. 131. No, 130. Oh, the group one new motion. 130.
My lord, 130, I am appearing for SBSTC led by Ms. Devosri Dhamali.
Yes.
My lord, the petitioner is absent today, my lord.
Are you ready?
No, my lord, I am appearing just not this week, my lord. Not this week.
Anyone appearing for the petitioner? This is a restoration application. The petitioner has chosen not to appear again. So let this also be dismissed. None appears for the petitioner. No accommodation is sought. Considering the conduct of the petitioner, the application being can of 2023 is dismissed for default. No order is proposed. Can. So read dismissed for us. Restoration.
Lordship, I am appearing for respondent number 326. Lordship, I am for petitioner. Lordship, the compliance has been done. The counter signature is done, your lordship. I am leaded by Mr. Mukherjee.
The allegation of counter signature.
Counter signature is
Yes,
done.
your lordship, it's complete. Lordship,
Nothing
the
further.
no, your lordship.
No affidavit.
My lord, this is record. Kept in record.
What is it?
The copy of the counter signature.
It is submitted on behalf of the parties that the State Transport Authority Jharkhand has issued counter signature to the renewed permit of the petitioner on 13 June.
13
June 2023. A copy of the countersigned permit and timetable submitted on behalf of respondent numbers 3 to 6 is taken on record. Paragraph in view of the above, nothing further remains to be adjudicated in the writ petition. And the same is accordingly disposed of. Origin certified website copy. Next.
Lord, I appear for the petitioner, my lord. So, very short matter, my lord. In the there, my lord, we have challenged. We are, my lord, the transporter, my lord. We were iron ore was not transporting. It was taken from the mine, my lord. Accordingly, my lord, there the quantity which we can take out, my lord, can only be transported. It was found to be overloaded on several occasions. We have issued, my lord, the notices to the railway representation seeking, my lord, that it is not in a proper sense, and the UMN notice. Railway initially did not, my lord, take any steps. Thereafter, my lord, the railway issued a notice saying that yes, the weighbridge is not functioning properly and it has been subsent. Thereafter, we issue, my lord, a letter requesting them to refund the money. That has not been done. But in the same case,
My lord,
penal amount. And
regarding
the
this
similar
matter,
case, my lord,
my lord,
your lordship has passed an
I have
case
some
order.
submission, my lord, regarding the maintainability and the jurisdiction point.
But this is
My
another
lord,
order, my lord, in the two companies, one
matter is, I
company
don't know
disorder.
what is the matter. And I think, my lord, in this matter, what point I want to raise, those point is not agitated in before this matter, my lord, which my learned friend is citing.
So let him make. his
My lord.
submission.
Yes, my lord.
Yes.
So, my lord, the gist of the fact is this, my lord, some wagons, 50 wagons was loaded iron ore by the petitioner company, and during the transportation, when reweightment was held by the railway authority in their own machine, that was overweightment was detected. And thereafter, my lord, the penalty was charged. They have preferred an application under section 79 for reweightment. And during pendency of that application of reweightment, they have taken the goods on payment of the penalty. So, my lord, kindly consider one question, my lord. This is a highly disputed question of fact. According to the petitioner writ petition itself, when according to my instruction, at that point of time and thereafter also, machine was correct. Although, my lord, in the writ petition, they have stated from a certain date that the machine was not functioning. My lord, that is paragraph number 5, my lord. That is on 21st November 2022. And my lord, in my case, my lord, the wagon was loaded and the reweightment was held prior to that. So according to the writ petition itself, my lord, that at that point of time, machine was working properly. Paragraph number 5 and 6. Paragraph number 6 stated that on and from 1/11/2022 to 19/11/2022.
Paragraph 6.
Paragraph 6. And paragraph 5, they have stated and suspended on and from 21st/11/2022. So according to the writ petition itself, my lord, that at that point of time, machine was working properly. My lord, kindly consider one thing. If one goods is purchased, my lord, and after using that, I am saying to the seller that your weight is not proper. So when I taken back the goods and used in my own work, so thereafter it is not possible to whether there was any really overweightment was there or not. Particularly on this aspect, our High Court division bench judgment is there. So, and not only that, my lord, it is a highly disputed question of fact. So when reweightment was held by the railway machine, that overweight was detected. Apart from that, my lord, at present, my lord, according to the section 106 of the Railway Act, my lord, before claiming any damages or anything like that, my lord, 106 notice is a precondition. No such notice was served, my lord. Not only that, my lord, according to the section 36 also, my lord, kindly consider two section, my lord. My lord, I want to show, my lord, just 3-4 lines from his writ petition, my lord. Kindly see the page 141, my lord.
Lord, my writ petition, my lord, he was supposed to
As
argue on
because,
the
my lord, I am
maintainability
raising
point.
the maintainability point.
Yes, my lord, he has not raised.
Only to the maintainability issue.
My lord, as because I am raising the maintainability points, for this reason, my lord,
Only
I
on
have to
the
take the first. Maintainability is
not on merits. Only on maintainability issue.
not on the merits. So, my lord, admittedly, page 141, 145, they have taken the goods. Goods is taken back,
That is on merits. Yes, sir.
admittedly. And my lord, kindly see
So let
the
us-
section 106 and 36, my lord.
106.
Let the petitioner raise his case first. Because your only ground is.
At present, my lord, after the, my lord, the amendment of the Railway Act 2017, my lord, all the claims related and freight related matter are to be decided by the Railway Claims Tribunal. And accordingly, my lord, our Honorable High Court was also decided the issue. And my lord,
What is the provision?
section 36 of the Railway Act.
36. Oh, yeah, tribunal.
Your lordship got it, section 36. Any complaint that a railway administration is contravening the provision of section 17, my lord, this is not applicable. B, is charging for carriage of any commodity between two stations at the rate which is unreasonable. This is applicable. Is levying any other charges which is unreasonable may be made to the tribunal. That is, my lord, the at present Railway Claims Tribunal. And the tribunal shall hear and decide any such complaint in accordance with the provision of this chapter. And my lord, here the highly disputed question of fact is involved. And my lord, the second section 106, my lord.
Yes.
My lord, 106, notice of claim for compensation and refund of overcharges. According to the petitioner, here the overcharges. A person shall not be entitled to claim compensation against a railway administration for the loss, destruction, damage, deterioration, and non-delivery of goods carried by the railway unless a notice there is served by him or on his behalf to the railway administration to which the goods are entrusted for carriage, to the railway administration on whose railway the destination station lies, or loss, destruction, damage, or deterioration occurs within a period of 6 months from the date of entrustment of the goods. Any information demanded on inquiry made in writing from any of the complaint made in writing to any of the railway administration mentioned in subsection 1 or by on behalf of the person within the said period of 6 months regarding the non-delivery and delayed delivery of the goods with the particular sufficient to identify the goods, a person shall not be entitled to a refund on any overcharges in respect of the goods carried by the railway unless a notice thereof has been served by him on or on his behalf to the railway administration to which the overcharges has been paid within 6 months from the date of such payment or the date of delivery of such goods at the destination station, whichever is latter. My lord, I want to rely, my lord, to decision, my lord. দিচ্ছি, এটা পরিক্রমা দিয়ে দিচ্ছি। My lord, kindly see the first, the Sandsteel Manufacturing Limited Company. My lord, that was challenged before the Honorable Division Bench presided over by the then Honorable Justice Sanjeev Banerjee, and that Honorable Court was prima facie hold that order was correct. And my lord, thereafter, my lord, the appeal was withdrawn by the writ petitioner. My lord, kindly come to the page 16, my lord. Issue was framed. My lord, in that case also, the iron ore was transported and overloading was detected and penalty was charged. Considering the facts appear on, your lordship got it, page 16, middle portion. It appears to me that issue involved in the said was case with regard to the reweighment under section 78, but here the issue is demand based on alleged false declaration about the purpose of use of consignment in question, and as such the fact and issue of the said case is different from the present one and is not applicable to this case. Considering the facts appear on perusal of the relevant records available, submission on the parties, and
decisions relied upon by the parties, the issue arises for consideration in this writ petition, according to me, are as hereunder. Whether impugned order raising the demand in question with the reason passed by the respondent railway authority concerned in compliance of the earlier order dated such and such in WPC number such and such in case of writ petitioner is without jurisdiction. Whether the writ court itself can determine the freight rate on the consignment in question as per relevant circulars. Whether writ court can decide the issue of falsity of truthfulness of a declaration made by the parties with regard to the consignment in question, and whether it was a domestic purpose or for export purpose, which is the determining factor of the rate of freight, and whether the railway has the jurisdiction to recover the undercharges if discovered after the delivery of consignment. Whether in view of section 33, 36, 38 and 44 of the Railways Act 1989, tribunal is the appropriate forum for adjudication of nature of dispute involved and relief claim in the instant writ petition. Considering the facts and circumstances of the case, perusal of relevant record, submission of the parties and relevant provision of law and judgment cited by the parties, my answer to the aforesaid issues are hereunder. In view of the order passed by this court dated 14 February 2011, in earlier writ petition filed by the petitioner herein, giving liberty to the respondents, it cannot be said that the impugned demand notice with record reasons are without jurisdiction. Writ court is not the appropriate forum for determination of rate of freight on a consignment, and there is no specific bar under the Railway Act 1989 in recovery of evaded undercharge freight if detected after delivery of consignment in the facts and circumstances of the case. Writ court is not the appropriate forum to adjudicate the disputed question of facts about falsity or truthfulness of a declaration made by the parties about the consignment in question, and to inquire about the issue on the same as to whether it was used for the domestic purpose or for the purpose of export. Taking into consideration the facts and circumstances involved in the case, and after considering the relevant provision of section 33, 36, 38 and 44 of the Railway Act 1989, which were not considered at the stage of admission of this writ petition, I am of the considered view that the tribunal is the appropriate forum for adjudication of the nature of the dispute involved and relief claimed by the petitioner in the instant writ petition. In view of the above discussion, I am not inclined to give any relief to the petitioner in the writ petition. However, liberty is granted to the petitioner to approach the tribunal against the impugned orders of demand in question within 6 weeks from the date, and if the petitioner file appropriate application before the tribunal within the stipulated time, it will not raise the question of limitation. Considering the facts in this writ petition by interim order dated such and such, respondent were restrained from taking any steps of recovery of demand in question, and same shall be continued for a period of 8 weeks from the date of petitioner, are also at liberty to make appropriate application before the tribunal for interim protection. Tribunal shall make all efforts to conclude pass and final order within 6 months from the date of filing of such application by the petitioner. And my lord, one thing, my lord, the petitioner herein annexed, my lord, so many railway receipts, that is RR, according to the section 64 of the Railway Act. That is, my lord, prepared by the petitioner himself, not by the railway. Sorry, and my lord, the next decision, my lord, that is also a division bench decision of our Honorable High Court, my lord. My lord, from the last paragraph of first page, my lord. The appellant says that the appellant made the payment as demanded under protest to obtain the delivery of the goods covered by the railway receipt, but the appellant did not make any demand for reweightment of the wagon at the destination station or any other place. Section 64 of the Railway Act 1989 consists that the consignor of a goods on the railway declaring the weight of the goods and the railway receives to carry such weight. Section 78 of the Act permits inter alia reweightment of the goods at any time. My lord, that according to the section 78, my lord, that weightment was done. At any time, sometimes reweightment is carried out in motion if there is a weighbridge on en route to the destination station, and it may not always be possible to inform the consignor or consignee for their representation to be present at the time of such reweightment. However, Section 79 of the Act permits a consignee or any person interested in the goods to protest the demand for payment of additional charges and penalty as may have been made under Section 73 of the Act. Once such a protest is made, the consignee or the person interested in the goods has to demand a reweightment. Damage and other charges can be levied in the event upon the reweightment. The figure cited by the railways comes out to be correct and initial figure submitted by the consignor turns out to be incorrect. Even the right under Section 79 of the Act is not absolute, in the sense that the right to seek reweightment depends on the matters of public interest, since a particular station may be too congested or a weighbridge may not be available. However, without any reweightment being sought, there is a little scope for challenging the demand made by the railways for additional weight or overweight or for penalty or the likes, as in the present case. It must be appreciated that the difficulties arises since the goods are carried on trucks and it is difficult to obtain weighbridge on trucks. In the present case, there is no doubt that the appellant herein or the consignee or other person interested in the goods protested the additional demand made by the railways, but there was no simultaneous request for reweightment in such a scenario without there being any further reweightment. The appellant cannot demonstrate that the weight recorded by the railway during in the motion weighbridge were wrong. In the light of the award, the writ petition has been appropriately dismissed by the writ court, and the judgment of the other impugned order dated such and such do not call for any interference. And my lord, in our case also, my lord, there is no scope for reweightment, as because my lord, after payment of the penalty, the goods delivery was taken, my lord. And whatever may be the, my lord, in the railway receipt, weight was declared, that was voluntarily declared by the petitioner himself. And it is their duty, at the time of reweightment under Section 78, to the record of the weight of the record in the RR, that is to be correct. But in our case, my lord, that was found that is not correct.
Let us hear the petition on the maintainability issue first.
Yes, ma'am. But I'm grateful to my learned friend for,
So, Mujumdar, the order is amenable to appeal.
no. But this order, to the best of my understanding, is not amenable to appeal. May I demonstrate to your lordship why? For that, since my learned friend has cited two judgments and also referred to the provisions, I need to take your lordship to two documents in my petition. Kindly take for once my annexure 142. What is the cause of action in the present writ petition? Kindly take, my lord, this is dated November 18, 2022. Kindly take the subject. My lord has got that?
142.
I'm so sorry. Yes, my lord, 142.
Yes.
My lord, the subject was excess recording of payments by EI not maintain the way.
We would like to place before your good self the following facts to impress upon you that there is no possibility of wagons getting overloaded at the loading point. Material is shifted to the loading point through government approved road way bridge through a transit pass. The railway bridge way bridge has shown in excess of the quantity that is actually shifted to the loading spot. As per Odisha mining rules, material cannot be stacked or stored in a railway siding until or unless Railways offers permission for commencing the loading. Mining operation, mining department gives the permission to load the rake under dump and load system. No customer can leave the material at the siding after the rake loading is completed. The points highlighted above drives us to the argument in favor of the opinion that the probability of excess loading over and above the quantity offered is remote. We had incurred heavy burden of paying penalties along with associated costs that are unexpected, and we strongly feel all this could have been avoided. You may kindly peruse the statement attached. Our prayers for revamment, well, we've already made prayers of revamment of the rakes have been turned down by the railway. May kindly see the letter addressed to PCCM SER, that is Southeastern Railway. You may appreciate that we are highly aggrieved by this situation. We seek your immediate intervention in this matter, lest it will cause immense damage to the finances of the company. We solicit your intervention to initiate immediate steps to address this damage by following measures. Now, kindly take the first prayer which we made in our letter. Suspension of the EIMWB at Benapur till the recalibration is done. Rewayment or weighment of the rakes at the destination point where the consignee's weighbridge is available. Refund of the penalty charges which are levied based on the defective EIMWB at Benapur. At present, one rake is awaiting adjustment of load. Following recording of overloading, we accept that the adjustment of the purported overloaded wagons under protest only in order to avoid detention of the said rake. Now, we'll kindly turn over and take page 146. Well, I made this representation on 18 November. Then an inspection is carried out. Now, what is the finding arrived at by the railway authorities with respect to the said weighbridge? Commercial control KGP from CWC, KGP, BP, EIMWB suspended from 1830 hours on date 21/11/2022 on so and so during inspection in the reading of the weighments found out of range. So, my lord, whatever I submitted, this petition does not involve at all disputed questions of fact. I submitted that whatever recording that the weighbridge has made, that recording was incorrect because of a faulty weighbridge. And it was found by the authority as recorded in this inspection report and the direction issued by the competent authority that yes, it was out of range.
On and from 21st.
Yes, madam, it has to be because I may.
Madam,
Prior thereto. Undoubtedly prior thereto. Because we registered our complaint, only then, my lord, this inspection was carried out. My lord, our prayers for rewayment were turned down. Now, my lord, kindly turn over and take the next page. That is our further representation. This is 30th November 2022. This is page 147. Well, kindly take the dates. Well, Lordship was looking for the dates subject to correction. Malad, I make this representation as per earlier letter dated 18 November regarding the excess recording of weighment at BP Benapur consignment is loaded at X DATR so and so. We had brought to your kind notice that below mentioned rakes were weighed at BPE and error in quantities in excess of normal load were found. Railway has raised penalty on the excess quantities thus recorded at BPE. We have reasons to state that the weighment recordings at BP are not acceptable. The subject rates following unloading at our sidings and cargoes shifting through our weighment system could not detect any excess quantity. The quantity of iron ore fines and cargo and loaded quantity by OMPL at the Daitari siding is same as the unloaded and weighed cargo at the consignee's end. Moreover, railway had got the weighbridge at BP inspected and it is said to have been advised for suspension till further advice, and the reading were found out of range. When were the consignments moved? One from 1-1 to 9-11, 1-11 to 9-11. 19 is there, but prior to 19, we had already made the representation. On 1st November itself, we made the first representation, which your lordship will find at page 145. On day 1, when this happened.
11th,
Kindly take my representation at page 145 for once.
this is 1st November.
1st November. That is on day 1. That is the date when the first rake was detected as overloaded because of their faulty weighbridge. So, Mala, it is not that I waited for 18 days to register my demur against that, Mala, incorrect readings. So, on day 1, I registered my demur and in writing too. And I prayed for reveyment. At that stage, it could have been reweighed.
Section 36.
Now, Millard, kindly take section 36. Again, I am grateful to my learned friend for referring to section 36. Kindly take, my lord, section 36. So, my lord, what we are concerned with in this litigation is imposition of penalty arising out of alleged overloading. That is the case at best. My case is that it has been detected later on that yes, my apprehension is correct, that the weighbridge was faulty. Now, any complaint that a railway administration is contravening the provisions of section 70, that is not the case. Admittedly, that is the stand taken by the railways today. B is charging for the carriage of any commodity between two stations at a rate which is unreasonable. That is also not the case. It is not the case of any charge over excess charge, excess rate being applied to a commodity which is being moved from carriage, which is being carried from one station to another. I am not challenging the rate. C is levying any other charge which is unreasonable. This is penalty. This is not charge. May be made to the tribunal, and the tribunal shall hear and decide any such complaint in accordance with the provisions of this chapter. So, my lord, this jurisdiction of the tribunal is well defined under section 36. And in my most respectful submission before lordship, that none of the criteria laid down in section 36 is met in the facts and circumstance of this case. Now, coming to section 106. My lord, section 106 cannot be read in isolation. Section 106 has to be read conjointly with section 107 and section 108. May I just read section 106 for your lordship's kind consideration. A person shall not be entitled to claim compensation. But I am not claiming any compensation. First of all, against a railway administration for the loss. That is not the case.
I think 106(3) should be relevant in this.
And a person shall not be entitled to a refund of an overcharge in respect. Again, Mala, that with respect to the rate. This is a case of penalty under 73. Overcharge in respect of goods carried by railway unless a notice therefore has been served by him or on his behalf to the railway administration to which the overcharge has been paid within 6 months from the date of such payment on the date of delivery of such goods at the destination station, whichever is later. But why I emphasize with your lordship that 106 cannot be read in isolation. It has to be read in conjunction with 107 and 108. Kindly take section 107 for your lordship's kind consideration. But this is the application pursuant to a notice of claim. Application for loss, an application for compensation of loss, destruction, damage, deterioration or non-delivery of goods shall be filed against the railway administration on whom a notice under 106 has been served. 108, person entitled to claim compensation. If a railway administration pays compensation for the loss, destruction, damage, deterioration or non-delivery of goods entrusted to it for carriage to the consignee or the endorsee producing the railway receipt, the railway administration shall be deemed to have discharged its liability and no application before the claims tribunal or any other legal proceeding shall lie against the railway administration on the ground that the consignee or the endorsee was not legally entitled to receive such compensation. So it's a case of compensation. And so far as subsection 3, your lordship was quite correct. My lord, I must deal with subsection 3. It is in respect of an overcharge. It is not in respect of a penalty. It cannot be in respect of penalty. Now coming to the judgment cited by my learned friend, the first one I take. একটু ওই যেটা আরেকটা মোটা মতো judgment না ওটা একটু দিও kindly. হ্যাঁ. মানে kindly take my lord the judgment rendered by the Honorable Division Bench presided over by Justice Banerjee, as his lordship then was.
Further, does the railway require to bring a come
Yes,
back with a report or not necessary?
Well, I believe, my lord, I believe this matter has to be decided on affidavits.
That is,
This matter cannot be decided upon hearing. Well, the lordship will kindly take, my lord, the division bench judgment dated 27 January 2022. In fact, the division bench had gone into the merits of the case.
Yes, yes.
Though the facts are not opposite to the
This is
facts,
merits.
it's on merits. And that the other judgment, it is about the truthfulness of declaration. Well, I am not concerned with truthfulness of declaration of either of the parties.
Will you come back on affidavits?
My lord, just one sentence of.
One more matter, just a second. But in a similar matter, but in an identical matter, your lordship has been pleased to pass an order directing that legal metrology office has to be implemented as a party respondent. That is in the.
For repayment.
Yes.
In this matter, my lord, those point was not raised, so there is no question of
Well, I
any
have
decision
not
from your
concluded
lordship.
yet. May I conclude first? May I conclude? Well, coming to the judgment rendered by, yes, my lord, Mr. Justice Nidam. Yes. Kindly take, my lord, this is the judgment where your lordship will find. Kindly come to the operative part of the judgment. Again, my lord, all these things happened after exchange of affidavits. I believe so. Subject to correction by my learned friend. My lord, kindly come to page, my lord, page 10 of the judgment. Your lordship will find the pagination at the bottom of the page.
Yes.
In my view, following provisions are required to be considered for final disposal. My lord, this lordship considers section 33, that is the constitution of the tribunal. Section 36, I have already established, this is not a case under section 36. 38 powers of the tribunal, 44 reliefs which tribunal may grant. Then, my lord, in case, and now I would like to discuss hearing the judgment cited by the petitioner. Then, my lord, the judgments are all quoted. My lord, what was the case? This was a case of evaded freight, which goes to the rate factor, which goes to the rate of the freight, which was the movement of freight, which was carried from one station to another. Kindly come to internal page 14. In the above cited case, according to me, there was no adjudication by the court on the first issue of application of coercive measure by the railway authority for recovery of evaded freight. This is the case of evaded freight. It is nobody's case before lordship that the petitioner before lordship has evaded freight. It is a case that the rakes were found to be overloaded. And it is my case, and I've demonstrated from their document that subsequently on a complaint registered by me, it was found, yes, the way bridge was not functioning properly. Indisputably, that fact cannot be disputed.
The dates are in dispute, actually.
The dates are in, but my lord, I registered my complaint on 1st of November.
The council says that when your consent was paid,
Am I to be blamed for inertia on the part of the department? I registered my complaint on 1st. They were duty bound. I am a regular operator in that area. But it was the duty of the railway to examine the way bridge.
Mr. Mujumdar, I think it would be better if the railway comes back clarifying its stand.
Yes, let them.
Yes,
My lord, only. My lord.
You come back with
My
the
lord,
report.
just two, I want to show my
Are
lord.
you ready with the report?
No, my lord, one thing just. My lord, just now I have received one instruction. My lord,
according to the mechanism of the weighbridge, my lord, if weighbridge is not correct, my lord, automatically if any weights, my lord, that will show result 0. So
let that
weighbridge is not functioning properly. In that case, my lord, the entire weight will show 0. But in that case, my lord, the 50 wagons was weighted and particular result was shown. So there is no question of
let them
any,
file that.
there is no question of any, my lord, that machine was not functioning properly.
The
And
what
not
is the
only that,
basis for submission.
There must be something on record.
yes, my lord, that is the mechanism of the machine, man. And my lord, one thing, my lord, according to the petitioner, but my lord, my instruction is this: at that point of time, machine was working properly, and according to the petitioner also, my lord, the kindly see the particular date when after weighment was completion. Thereafter, the machine was which was the page 171, my lord. That particular date, my lord, that is
Will you please put all this
yes,
on
yes, my
affidavit?
lord.
Yes, my lord.
That is, my lord, 21st 11/2022.
My lord,
And
these state-
before that, my lord, weight was completed. And my lord, one thing, just one line from the page 177,
The machine was suspended. So not necessarily.
machine was suspended after
21st.
completion of the, my lord, the
First.
weighment.
But the application was put in on 1st November. So we cannot necessarily infer from this.
So,
that
my
the
lord,
machine
if
was out of
machine,
order from the 21st and not from the 1st.
if machine is not working, my lord, and that case, in that case, my lord, no result will found.
How do you come to this? How do you arrive at this conclusion?
And my lord, kindly consider one thing, my lord, page 177.
Cannot be only a submission of from the railways.
This is my instruction, my lord.
But that has to
On
be
the
in
basis
writing.
of what?
This is I am submitting, my lord, on instruction. My lord, kindly see the page 177.
I would like to have this on affidavit.
Just one line, my lord, one line and one word from the section. My lord, page, এটা কত গো তোমাদের? 177 নাকি?
47.
My lord, 147.
147.
My lord, page 147, second paragraph.
Yes.
We have reasons to state that the weighment recording at BPE are not acceptable. The subject rates following unloading at our siding, subject rates following unloading at our siding, and carriage shifting through our weighment system. So, my lord, the delivery was taken. So after delivery, my lord, it is not possible for any reweighment. And my lord, I want to show, my lord, just one word from section 36, my lord. 36, my lord. In my case, my lord, my submission is this: 36 subsection B and C is applicable. And kindly see, section C of the 36 is leaving any other charges. My lord, any other charges also includes
Penalty.
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 Very good.
And my lord, kindly, I have not.
To agree. Any other charge
No, it
should
cannot,
include
madam.
penalty.
Well, like any other charge, my lord, cannot include penalty because penalty charge would entail civil consequences, my lord. It may be demurrage. It may be wharfage. Those charges are there. They are provided in the railway schemes for payment schemes and all that. But when it is a case of penalty, when a penalty is a distinct and separate imposed, even when compared to other charges, it's a different. Any fiscal legislation, your lordship has dealt with those. It's a separate levy altogether.
And
It's a
my
levy.
lord, kindly direct the petitioner that out of 150 pages of petition, more than 85 pages is not at all legible. Now, although I have not stated at the very beginning, my lord,
Please give him.
but it is also known to the learned
And I
advocate.
agree with him, and in fact, my copy is also not legible. But I would also like to be given a better copy.
In case of my lord affidavit, it is very difficult for us to state it anything.
Definitely. But we will arrange for a better copy by tomorrow.
Will you come back with a report in the form of?
But let them file a report. We can take an exception. That will
Come back with a report.
And my
of the
lord,
submission affidavit.
in that case, my lord, kindly recorded at least regarding the maintainability point submission.
I'll keep it open, yes. Third learned
Then
counsel.
metrology may also be included as a party in the earlier matter.
And regarding that, I have no objection, my lord. Regarding the report, my lord, I have raised, because I have raised
On prayer of
maintainability.
the petitioner, liberty is granted to implement the legal metrology. Please give the full nomenclature. Mr. Majumdar, the full nomenclature and address is required. Legal metrology.
The inspector, my
Complete,
lordship has passed this order. Inspector Legal Metrology Office, Kharagpur, West Bengal.
The Inspector Legal Metrology Office,
Kharagpur, West Bengal.
Kharagpur, West Bengal unit be included as respondent number 7 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly. Paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on the adjourned date. Paragraph, learned counsel for the railway authorities seeks to use a report in the form of an affidavit in this matter. Paragraph, let the matter appear. When will you come back? Under the same heading.
4 weeks, my lord. 4 weeks.
Yes.
4
4
weeks.
weeks. 2nd August.
The next, the other matter is appearing when the lordship is directed.
7th.
That same matter would appear on July 10th.
7th. 14th.
তাহলে ওটা আগে হোক।
I think he needs some time.
Yes, yes.
2nd August.
Great. So great.
And my lord, the maintainability point kindly record.
No, the
I
issue
have,
of maintainability is kept open.
I have relied to decision also, my lord.
The issue of maintainability is kept open.
Code numbers. My lord, I don't know about petitioner, but I am for respondent. They have not served us the copy. So, and we have, for that reason, we could not file a vokalatnama. So I require time for filing vokalatnama.
Let's say I'm for the petition.
You are appearing for whom?
I'm from Kanishko Shina.
You are the petitioner.
I'm for the petition.
You have not served the private respondent.
Lordship, I am serving now.
No.
There was some mistake, Lordship. This time kindly pardon me.
So the affidavit is not ready.
No, we have not filed vokalatnama also.
So please complete your service and come back.
Lordship, I am just now I am giving the.
Are you ready with your affidavit of service?
Lordship, on the.
Because I required few days time.
You are planning to serve now.
Lordship, I am serving
Affidavit of service.
on the next date.
Because she has not filed her power vokalatnama.
As your Lordship, kindly fix another short date, my lord. My mistake, it will not occur.
Since affidavit of service is not ready, let the matter stand over till 28th July.
Lordship has fixed another matter on 11 July yesterday.
Not such short date. Come back on 28th July.
Lordship, kindly make it 11 July, Lordship. 28, Lordship.
Different matters.
No, same matters, Lordship. Pertaining to e-rickshaw registration. Lordship has fixed on 11. So
Where? 11 July.
I'm grateful. Lordship, I am handing over the copy. Lordship, kindly record that I have
Affidavit
served.
of service in court.
Yes, Lordship.
Both-
Lordship, kindly
both are
record that I have handed over the copy of the.
Of service যেটা বললাম since তার আগে করুন actually. Copy of the writ petition along with annexure thereto is made over to learned counsel for the private respondent by learned counsel for the petitioner in court this day.
I'm grateful.
Purpose, since affidavit of service is not ready. Adjourn.
Office copy.
But 133 and 134, both are same.
134 also same?
Same.
Same order.
I'm serving both copies of the writ petition.
আচ্ছা, এটা GHOSH. Since
এই টপ দিয়ে দিলাম
on share of the balance.
ব্যাস না না আমি সার্ভ করে দিয়েছি You are, how can I serve you? You are representing, you have to accept. Order has been recorded.
133, 134, same on. Next,
I'm grateful.
133, 134, duto eleven.
135, my lord, I beg to appear for the petitioner, my lord. May I have my affidavit of service? My lord, my prayer for curtailment and extension of.
Please, give me a minute, sir. Respondents.
I have served everyone.
Mr. Bandyopadhyay, may I request you to appear in this matter? You are silent. You should make a submission to that effect.
I do not know whether he is saying or.
It has been served on the state. No one is appearing. So I would request you to appear in this matter.
There should be.
Mr. Devra, where is he?
My lord, very short point is involved. My lord, the RTA board has already adopted a resolution, my lord, allowing the curtailment and the extension of the route, my lord. Only difficulty is, my lord, I am operating on the old timetable. They have not, the new timetable has not been issued. In respect of the extension of the route, my lord. SLP2 is the resolution, my lord.
What is your prayer only for issuance of timetable?
Yes, my lord. Of the first timetable after curtailment and extension of the route, my lord. Serial number, my lord, the last one. Samama Transport Company in the name of Rabindranath Das, my lord.
The revised route is approved.
Yes, my lord. In the board meeting, my lord, the board meeting resolution I will speak to my lord. Copy of the my lord resolution is attached. My lord.
Where is the resolution pertaining to you?
And it's a P2, my lord, the board meeting.
Sir, Rabindranath
Last, Rabindranath Das. The last one.
Subject to submission of clash-free timetable. Have you
Yes.
submitted the timetable?
Yes, my lord, I have submitted.
It has not been approved as yet.
Yes.
I do not find anyone else today.
No, a decision may be taken by the secretary. Let him take a decision.
Mr. Bandyopadhyay, you have heard the case? I'm requesting you to appear in this matter. Why such a casual approach, sir? Simple matter, resolution. Give him a copy, please.
Consideration.
Thank you.
It may be considered, my lord.
Implementation of this resolution.
Yes, madam, nothing more than.
That's all.
Court appointed. Yes.
Affidavit of service. None appears for the respondents despite service. Mr. Bandyopadhyay, onar namta diye deben, who is present in court, regularized court, office of the direction. Paragraph. The petitioner pays for implementation of the resolution taken by the RTA board in its meeting held on 27th March 2023. the resolution taken by the board is set out. Page 11 annexure P2 the extension portion থেকে clash free timetable. Last column. Paragraph. Learned counsel for the petitioner submits that though he has submitted a clash-free timetable before the authority, comma, no further step has been taken by the authority for approval of the same. Paragraph. Learned counsel for the respondents submits that the secretary should have approved.
Chairman. So number 4, my lord.
Yes, the fourth respondent be directed to consider the timetable submitted by the petitioner in terms of the resolution dated 27th March 2023. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to consider the timetable submitted by the petitioner.
Kindly mention in respect of the new route from Puraton Gram to Nawab.
As per the resolution, my lord.
Yes, in terms of the resolution.
In terms of the resolution.
Petitioner, in terms of the resolution taken by the RTA board on 27th March 2023. Within 1 month?
Or within
6 weeks.
6 weeks.
Within 6 weeks from the date of communication of this order. Further hearing is not required.
No, madam.
No, madam.
Comma in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, which Next.
Paragraph 136.
Yes, affidavit of service. Mr. Sen, you're appearing?
Mine.
Regarding gross vehicle weight of a vehicle.
Gross vehicle.
Gross weight. 2016, 2018, 16th July 2018 and 6th August 2018, page 15 and 16. Central government issued notification regarding enhancement of gross vehicle weight. Let's kindly turn to page 15 and 16. Just explanation, last paragraph.
Yes. Tolerance up to 5%.
5%. My vehicle, my two vehicles, they are carrying more than 5%. Within extra 5%, within extra 5%. That I have annexed the authority concerned seized my vehicle, thereafter they issued challan and compel me to pay the fine. Let me kindly turn to page. This notification also accepted by the state government, that is page 18. Consequently, then page 20 is my registration certificate. The maximum carry can weight carry 47,500. So 47,500 and extra 5%, extra 5% would be
475 divided by 2 kore dibe.
2375, that is equal to 49875. Let's kindly turn to page Lordship, can you 25, 24 and 25. Sorry, 25, my lord. 25. That is my lord 47575. One vehicle. That is my lord vehicle number. Last two numbers 82. And my lord the next is page 26. My lord, that is my lord 47,540 kilograms in respect of my lord vehicle number 321. So, Malad, they ignoring this Malad central government notification as well as Malad state government notification. Malad challan has been issued. Lordship, kindly see. Malad, that is page 22, Malad. Page 22. And payment I have made, Malad, page 24. $27,000. $22 and $27. Two allegations against two sections for extra carrying the goods and rash driving. Rash driving, they have calculated since it is carrying extra 5%.
Where is the calculation?
Calculation
of rash drive, the fine, the penalty?
Yes.
Page 23. 23.
Pardon me. Carrying excess load, 103 of the Motor Vehicles Act, 22,000 fine. And second, driving dangerously, 184 for alleging violation of 184.
This is for one of the vehicles.
One vehicle. And Malad, there are two vehicles. That is Malad, two goods I have Malad.
What about the other vehicle?
Yes, Malad, page 21.
How do you explain the dangerous driving part?
Because Malad, it is their content since it is Malad carrying extra load. It is carrying extra.
That is one aspect.
Money.
Dangerous driving is another aspect. So dangerous driving you cannot deny.
Malad, dangerous according to me, Malad, there is no dangerous.
Not
driving.
in fact denied in the representation also. Not in fact denied in the writ petition also. In the, my lord, the representation at page 27.
Which part is denied?
Yes, only that, my lord, the relief that is claimed that 5% that is the mentioned in the 2018 notification, that, my lord, that should be extended, or why it has not been extended. Extra weight up to the 5% in the gross vehicle weight shall be allowed.
But apparently it is within the 5%.
My lord, it is, my lord, I cannot deny that.
Will you come
Because,
up with a
yeah,
report?
no, my lord, I do not think. Now the position is this, that after the challan having been served upon him, it has been paid. So kindly consider this. It has been paid. Now, there is no such, my lord, I don't think there is any such document that when it has been paid or they fulfill the demand made, then that was any without prejudice to their rights or, my lord, upon objection, nothing. After that, that means you have accepted that. This is one-way submission. You have accepted this. After that, now you have come back and said that no, it was demanded wrongly and or I paid wrongly. Now, my lord, I do not want to stand in the way only on that, my lord, technical point. Because if, my lord, somebody paid, which he was not otherwise, my lord, liable to pay, then, my lord, something is to be done. But I have not, my lord, gone into any such provision with regard to the refund. Now, and my lord, the officers with whom I have made contract, my lord, they also could not satisfy me. So better, my lord, though representation before the Secretary Department of Transport, but I don't think that Secretary Transport,
Have the authority.
yes, my lord, better if your lordship,
The board.
no, I think the Director Transport or my lord, the Secretary Transport be directed to depute an officer who can, my lord, consider this. আপনার কিছু বলার নেই এখানে, আমি যেটা বলছি তাহলে আপনি প্রাইম মিনিস্টারের কাছে চলে যান।
Another thing is.
আমি
the
চাইছি আপনার প্রবলেম।
There is no prayer for refund of the amount also.
There is a judgment of this honorable.
In the representation, there is.
No, in the
prayer for-
representation there is no.
For refund of the amount. You have only prayed for taking necessary steps.
My lord. So, my lord, my prayer, lordship kindly see my prayer, and my lord, lordship kindly turn to paragraph 7 of my writ petition, where I have disclosed that I am compelled to pay the, my lord, amount unless and until I will pay the, my lord, amount my truck will are not releasing, my lord. I am compelled to pay. And if I pay anything and the authority concerned accept the same wrongly.
That is the practical scenario actually. Trucks will be intercepted if the fine is, the penalty is not.
But that is why what I wonder. My lord, I think, my lord, he could not, my lord, understand what I want to say. If he says that very good, then the matter can be resolved by filing affidavit. Then I have to file affidavit. না না জাজমেন্ট নিয়ে কি করব?
আপনি বলবেন আমাকে আবার দেন কি দিচ্ছেন জজ সাহেবকে বলছেন না।
I wanted to solve the matter, but if he says that no, he want to go to the merits
Let
in
us solve
this way. My suggestion is, lordship, let him make a comprehensive representation before the Secretary Transport, and the direction be given upon the Secretary Transport that let him depute a competent officer who will adjudicate this, my lord, after giving him an opportunity of hearing within a specific period. Because I cannot say, my lord, director or additional director, or let him decide, the transport secretary, that who will, my lord, adjudicate the matter.
Well, all documents before your lordship.
The overweight part shall be refunded,
My lord.
not the the dangerous drivers. Because that has not been pleaded and that cannot be actually controverted. Dangerous driving is on the spot.
Yes, I am not, my lord, that is, my lord, the dispute
That has
He
to be
may,
clear.
yeah, that, but so,
No, but in another matter.
so
I
far,
appeared before your lordship with some vehicle owners. Those who claim their allegation that when their vehicle was playing on the road, they are not allowing to extra 5%. On that petition, I could not produce any documents that they have collected or take the challan or the fine. Lordship, can you see?
This will not really help you in this matter.
Just, Lordship, just, this is the fact,
Affidavit of service. So you still want to file a representation before the authority for taking necessary steps?
Only my
Refund.
amount,
That's all, that's all. So it has come down to boil down to that.
my lord, would your lordship be kind enough, my lord, to send this matter to the, my lord, the authority, or my lord is going to, my lord, pass the order? I think, my lord,
I'll pass the order. Refund order, I'll pass. Authority, there's nothing more to consider.
then, my lord, may I tell, my lord, my lord, I would be in a difficulty without any report or affidavit. Lordship, kindly consider my position.
That is why I asked you.
My lord, then, my lord, I shall file. Very short, my lord, 2 weeks. Then I have to file because my lord, kindly consider, my lord, if your lordship want to,
Pass an order of refund.
my lord,
I intend to pass an order of refund.
yes, then my lord, kindly,
Very clear.
my lord, I cannot want,
So
my
you
lord,
want to come back with a report?
yes, my lord,
Very
because
good.
lordship, kindly consider one thing.
Since I have
On behalf of authority,
I understand.
then my lord, I have to, lordship, kindly
That's
consider.
the reason why at the outset I asked you
My
whether
lord.
you
No,
want to
I thought that matter can be done in other way.
come.
That
Come.
very good.
Affidavit of service.
কে করেছিল এটা? কোথাকার?
Uh,
রেসপন্ডেন্ট কে আছে? উত্তর দিনাজপুর, ও বাবা।
for a direction upon the respondents to
My lord, respondent Islampur.
this is the prayer of the petition
Yes.
to refund the penalty imposed upon the petitioner for alleged excess gross weight of the vehicles owned by the petitioner.
Registered transport officer মানে?
The petitioner relies
Assistant
upon
registered transport authority মানে?
Technical.
the circular, the notification issued by the
Is the
Ministry of Road Transport and Highways
আসুক এসে অ্যাফিডেভিটটা করুক।
What is the date of this notification?
My lord,
16 July 2018.
notification?
Notification?
Yes, my lord. 16 July 2018.
16 July 2018, which reflects the maximum safe axle weight, AXLE, axle weight of each axle type in relation to transport vehicles. Stop. The notification further declares that tolerance up to 5% in the gross vehicle weight shall be allowed for the purpose of compliance to subsection 3 of section 113 of the Motor Vehicles Act 1988. Paragraph. Learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading
But a
on
report be filed, Lordship, by the respondent number 4, assistant. It should be ARTO, Additional Regional Transport Authority.
I have stated
Respond-
that learned counsel seeks to come back with a report.
Very good.
26th July.
26 July. মনে করিয়ে দেবে ওদের খবর দেবো।
My lord, next matter identical. Here, my lord, I have not posited the fine.
আমি নেই নেক্সট ম্যাটারে।
Next matter.
Mr. Sen is not appearing.
No, my lord. Somebody else.
Your affidavit is
এটা তো এখনো স্লিপ দাওনি। নেক্সট
Sir?
আইটেম নম্বর কত?
served.
137.
Anyone appearing in this matter? Mr. Sen, may I request you to appear?
My lord, then a
Same issue.
copy be served upon
Yes, yes.
same.
Same এখানে যে টাকাটা জমা দেয়নি যার জন্য ওর ওই ওয়েবসাইটে ভেকেল একটা বন্ধ করে দিয়েছে আর ওই দুটো
Then it is not a case of refund possibly.
Refund, my lord, I have not, my lord,
This is for cancellation and withdrawal of the impugned e-challan.
চালান এই চালান আর
Okay. এই একই অথরিটি?
একই হবে
আচ্ছা,
সেম
একটা কপি দিয়ে দেবেন,
হ্যাঁ,
তাহলে আমি
sure.
কাজ করতে পারবো না।
The same notification has been relied upon. এটা শুরুটা করুন। Affidavit of service. None appears for the respondents despite service. Mr. Sen's service appointment regularized for copy service and direction.
মানে one junior অসীমা দাস ছিল, somebody
Along
else.
with the junior of his choice. The writ petitioner seeks cancellation / withdrawal of the impugned e-challan issued against him on 10th May 2023. তারপরে the petitioner places reliance upon the notification টা যেটা বলেছি ওটা পুরোটা বলো।
মনে রাখবি এটা,
রাখে রাখে।
ওদেরকে নোটিশ করতে হবে।
Places reliance upon the notification. তারপরে report learned counsel for the respondent seeks to submit a report in the form of যা আছে ওটাতে বাকিটা শুধু শুরুটা ওটা same date.
My 26 July. I'm can you direct them a copy be served?
Yes, please.
Seriously.
In course of this day.
Tomorrow, not
Yes,
today.
all right.
Because of two.
All
Next. Respondents,
Applied for grant of new public matter, that application is got
who is appearing for the respondents?
My lord, learned advocate Mr. Pantudev Rai is appearing lordship on behalf of the state lordship.
Yes,
Thank
where
you,
is he?
not today. He's engaged in court number 5, lordship.
I paid for consideration of the application.
You can represent the state in this matter. You are appearing with him.
Lordship.
So shall I deal with the matter? Have you seen the brief? Have you gone through?
Yes.
Take these chances, madam. These are rare chances that the juniors get, isn't it? Yes, make your submission. Yes, Mr. Shankar.
Petition people must say apply for grant of public discuss permit. Is having new vehicles, application page, understood you want manner. I am paying manner that application be decided by the respondent in a particular.
The application be decided by the authority.
Board man.
Page 13.
Page 13 is the application matter.
This has not been considered.
This is to consider.
This has not been considered.
That not be considered.
Lordship, another matter was filed before this court, lordship, on 2022, lordship, and it was suppressed in this writ petition, lordship. And there was a direction to file, specific direction to file rupees 10,000 to respondent number 2, as per order, lordship. And lordship and
The same
and
issue.
Same issue. And as per lordship direction, lordship, petitioner was requested to appear before the responding number.
Please show me the document.
That application was moved, application was considered, grants was made, but of that application, during the course of operation, the permit was appears to be not viable. She made further application for new grant of permit. Because the new vehicle, he is supposed to pay installment higher rate, but he made a prayer for the authority for grant of first permit before the respondent two. Because section 69 in Motor Vehicles Act, major portion of the route lies within the jurisdiction of the road.
Madam ke dekho. Malot ke madam.
And that application was kept pending for a long time. After 5 or 6 years,
Here, offer letter was issued.
but that I'm not precise, it's a fresh grant.
Have you stated this in your
Yes,
petition? Where is it at paragraph?
But I don't-
Not stated, Mr. Shamanto.
Well, that submission is not there.
So it is
Lordship, I
suppression
think-
of material
But
facts.
there is no bar in making further application.
Suppression of material, there is no bar, but it should have been stated in the.
But I have submitted, surrender the permit.
These facts should have, since it's the same petitioner,
But I can sign supplementary between my, your logically grants are liberty. I can come back.
after the respondent points out, you have to withdraw.
Not necessary, under the law is not necessary, according to my humble submission. In law, it is not necessary. After the surrender of the permit, I have a right to apply for fifth grant of permit.
No one is denying your right, Mr. Shamanto, but you should disclose that in your.
But that is necessary, according to my humble submission, this is not necessary.
Will you come back with a supplementary?
Lordship, may I be permitted to show lordship the order of the last writ petition, lordship?
Please read the relevant part.
I can annexure all those things in my supplementary.
You'll come back with a supplementary affidavit. Do you
Lordship,
want to
may
come back-
I read the relevant portion?
Also want to come back with a report annexing these documents?
Lordship, as your
Yes,
lordship.
please do that. Affidavit of service. A learned counsel for the respondents submits that an identical application was made by the petitioner before the authority earlier
In different,
and
in different route, not in this route.
that is this cannot be withdrawn from this application.
It's
This is
different
the
route.
submission of the respondents.
Some submission of this, but there is
And-
different route.
Offer letter for granting permit was issued in favor of the petitioner on 20th April 2022. Paragraph in reply, comma, learned counsel for the petitioner submits that the said offer letter was issued in respect of a different route. And since the said route was not viable, comma, it was cancelled.
He surrendered, she surrendered.
The permit was surrendered by the petitioner before the authority. Stop. Learned counsel seeks to file a supplementary affidavit
Stating all these first.
stating relevant facts. Paragraph, learned counsel for the respondents also seeks to submit a report in the form of an affidavit annexing relevant documents. Paragraph, let the matter appear under the same heading on 28th July. Please take back these documents, madam. Thank you for your submission.
Didi.
Next. Mr. Debroy, I have insisted your junior friend to submit.
Stuck up. Division bench, code number 5.
That's very good because she got an opportunity to submit.
Very good.
My lord, one
Very
question, my lord,
Yes.
that
Very
case
good,
has
very
on-
good. Proceed.
only on case hard, my lord. My lord, I am pleading for not.
The petitioner is also not there. Petitioner,
My lord, I am for the petition.
Oh, so you have served the state only?
Yes,
this
ma'am.
much. What about the private respondent also?
My lord, private respondent, I have served, my lord, but he came back.
You have to serve again.
Yeah.
Serve again. You have
My
to
lord.
complete service.
My lord,
Since service upon the respondents is not complete, let the matter stand over till 1st August.
my lord, time to make it on next month, next month. On Monday.
1st August,
Past of.
August.
Yes, my lord.
You want it in July?
Yes, ma'am.
Where, 28th July. Next.
Yes, but in this matter, I am appearing on behalf of the petitioner.
Mr. Debroy for the state?
No, objection.
Yes.
But in this matter, I am holding a permanent interstate permit on the basis of reciprocal agreement in between the state of Jharkhand, state of West Bengal. Page number 19. Can you see the page number 19?
19.
19, page number 19.
Yes.
This permit was issued in the year 2019, first permit, 90. PSTB number, my lord, 1090, West Bengal.
বলেন নি তাকে তো দিয়ে দিবেন আপনার খেয়াল রাখো yes
Yes. Page number 19, this is the permit. This permit, my lord, first time, my lord, this permit was issued in the year 1990. At the top left side, permit number 1090. Very old permit. This permit was renewed time to time. And my lord, the permit holder, that is petitioner, has been plying the vehicle under the reciprocal agreement on the basis of counter signature, which is countersigned by the another counterpart. Page number 2, page number 21, page number 21. Third line, my lord, a permanent interstate carriage permit, PSTP number such and such, in favor of Srimati Subhankari Devi by the State Transport Authority of Jharkhand, valid for 5 years up to 20th February 2020.
yes
Therefore, my lord, permit was renewed. No, this permit that just I have placed before you already see. This permit, page number 19. This permit was renewed on 20th February 2020, and it is valid till 2025, serial number 11.
yes,
Yes, well. Lord, this permit was issued by the State Transport Authority Jharkhand. After grant of the permit, State of Jharkhand intimated to the State of West Bengal, State Transport Authority of West Bengal, to countersign. Page number 23. Page number 23.
yes
The Secretary of State Transport Jharkhand requested the Secretary of State Transport Authority of West Bengal to countersign. But till date, no permit has not been countersigned. So, my lord, I could not ply the vehicle. Without a permit will not be valid to the other region unless the permit is countersigned. So, my vehicle is ideal. Now, the section 80, subsection 8 provides that if any vehicle is attached with the permit, but there is no bar for issue for grant of permit, a special permit for on a special occasion. Suppose for to carry the excursion party, to carry the marriage party, to carry the pilgrimage party, there is no bar. So, under section 80, subsection 3, the special permit was issued, page number 20, page number 28,
28
page number 28, 28.
yes
This permit was issued by the RTA Dumka, that is the state of Jharkhand, at the bottom of Dumka. This permit was issued, serial number 11. Permit was issued on 21st October for 4 days, 21st
Yes.
October to 25th
25th
October, only for 4 days. And my lord, so far the interstate permit is concerned, my vehicle is ideal. In spite of that, I've been paying the tax time to time, because in terms of the taxing statute, if any vehicle in possession of the owner of the vehicle, whether it applied or not, tax must be imposed. Otherwise, my lord, tax token surrender will be surrendered, other document will be surrendered. If the tax is unimposed, the tax cannot be exempted. So I have paid the tax time to time.
So your prayer is for counter signature?
Yes, no, for another reason. My vehicle, when my vehicle enter in the state West Bengal, the vehicle was seized by the MVI motor vehicle inspector, Pushchim Barwan, on 21st, near Asansol bus stand. Asansol bus stand. No seizure list was issued driver. No seizure list was issued to the driver. Now, within 7 days, because vehicle was seized on 21st October 2022. Then, my lord, within 7 days, I visited to the office. Kindly see the page number 31. Page number 31.
So your vehicle was flying in West Bengal?
Yes.
With special.
Special permit. Special permit.
Special permit was only for 5 days.
For 4 days. For 4 days. And I have also enclosed the passenger list also. The vehicle was seized on the sole ground, but that I'm coming later stage because no seizure list was issued. Only the vehicle was seized on the ground that the vehicle was flying without permit, without registration, without registration certificate,
What was
without
the
test.
route in page 28?
Route, my lord, to carry the pilgrimage passengers, I'm placing. Yes. Route number Devghar, yes. Serial number 10, Devghar to Asansol. Route has been fixed. Devghar to Asansol. So I entitled to fly the vehicle to complete the route.
In a special permit, counter signature is not necessary.
No, not necessary. That is the law, my lord. Section 80 is very clear. Because but the regular permit is counter signature required under section 88. Regular permit. So for the special permit concern, there is no concern. Only, my lord, tax is required to be paid. Now can you see page number 31? On 28th October 2022,
Yes.
I met secretary, motor vehicle inspector, and submitted all the documents for verification. But I did not receive any response. So after, my lord, waiting whole day, then I compelled to make this representation and submitted all these documents. That I have returned back. Now can you say the page, next page number 32. After 28th October 2022, now, my lord, regional transport officer, that is taxing officer, Pushchim Barwan, my lord, filed memo dated such and such 17 November 2022. The petition was intimated to pay the amount. There is no breakup. Only the, my lord, total assessment was assessed. Amount has been assessed and computed without any provisions of the taxing statute. Only lump sum amount has been, my lord, assessed at the 1,92,568. But my vehicle has been engaged only to cover, my lord, 4 days under this special permit. Now this notice was issued along with this, my lord, seizure list. Page number, next page number 33. Page number 33.
Yes.
And serial number 7, clause number 7, that my detection nature of offenses detected, that has been recorded here by the motor vehicle inspector, seizing officer, that is recorded that without registration certificate, without CF, without permit, without tax and additional taxes to West Bengal, without driving license, without conductor license, nothing. But I could not place all those documents, the admitted fact. But according to section 130, subsection 3, if the driver or owner in the spot, if the vehicle is seized, fail to produce the documents, 15 days are required to be the time to place all the original documents. For this, within 7 days, I went, my lord, and submitted all the documents, but I did not give any response from the concerned authority. Then I submitted the representation and submitted all the documents. Now, my lord, after this, that I made a representation, page number 44, page number 44, page number 44. A comprehensive representation was made, requesting all the district magistrate, I sub the copy upon the district magistrate, secretary,
This is
and
a
motor
demand of
inspectors,
justice.
both. One of the requested authority to assess to verify all the documents and to assess if they are inadequate, because I have already paid that. All these tax token I have annexed up to date. Well, that was not done. Then I compelled to move the writ petition before your lordship. Then, my lord, after hearing the parties, both parties, Kindly see the page number 47. Page number 47. So, my lord directed the concerned authority, that is seizing officer, to consider the representation as per provisions of the taxing statute after hearing the party, after hearing the petitioner and authorized representative.
Yes.
After receiving this order, the assessment was made, page number 49. This is the subject matter challenge in this writ petition. Page number 49, Annexure 3.8. But this assessment was divided into two parts. First, my lord, the submitted documents that recorded. Serial number 1, the interstate permanent stage carriage permit being number such and such, route Devghat to Tarapet via Dumka, Rampurhat for vehicle number such and such under reciprocal agreement between Jharkhand and West Bengal. Now the observation ends scrutiny. Gross violation of route mentioned in this said permit, absolutely non-application of mine, because my permit, I cannot use the permit unless the permit is countersigned. That is admitted fact, because I am permitted to fly up to 20 February 2020. Now, it is not the matter of amount on expected, it is a matter of between the state transport authority and West Bengal, state transport West Bengal. Now, failed to produce counter signature because state has not countersigned, state transport West Bengal has not countersigned. So how can I place the counter documents or counter signature? A condition quoted by Secretary of State Jharkhand in the said permit that the vehicle that endorsed in the permit. When my vehicle 12 years cover, then I place it, because my vehicle idle since 2020. My 12 years cover will be covered in the month of June 2021. So this question cannot be raised. Now the next special permit. Regular, in the connection of the regular permit only. Second special permit. A special observation and scrutiny. No new permit, whether new state carriage permit as well as new contract carriage permit for all category of passenger transport vehicle on any road area within the municipal limit of Asansol city, Burdwan district shall be issued in terms of memo number such and such 20 October 2006 issued by the Transport Department, Government of West Bengal. Well, this notification issued by the Transport Department, then no further new permit will be issued touching and terminating Malot and from the Asansol city, from the city of Asansol. But here the special permit that is up to the Asansol. So I am not touching this Malot Asansol. So this notice is not applicable in my case. Secondly, surprisingly, two special permits are found for some route from Devghat to Asansol via Jamtora without authorized passenger list produced by the driver later on the day of seizure of vehicle number. In the seizure list, it is recorded the driver fails to single documents before the authority, before the seizing officer. Here you can say it is abstract, my lord. I do not know how, from where this has been. Now, because my lord, we have failed to produce any single documents. No documents lying with me. So this is I cannot accept this. I deny. Without any verification, this is question raised. Now, next, my lord, it appears that understand that the discrepancy is found on their submission of two special permits, because I have one special permit, not two special permit. So, my lord, this is not applicable in this case. Because in the seizure list, my lord, it has been recorded. I failed to produce in a single document. In the seizure list, that has been recorded. That the one seizure list, one, my lord, special permit was placed. On 28, when I visited the office, then, my lord, I placed the documents the first time. My next page, my lord. This is the main, my lord, this is the calculation assessment computed by the authority that the motor vehicle tax and additional taxes to West Bengal. No motor vehicle tax and additional tax has paid on or before the date of seizure of the vehicle. Kindly see the next, a series of tax token I have annexed. Page number 34. Page number 34. Onwards. Page number 34. Page number? Yes, page number 34. First tax was issued by paid. Yes, yes. The vehicle was seized on 21st October 2022.
So this is the document.
Tax was paid from quarterly from 1st October 2022 to 31st December 2022.
Yes.
Cover 8,656. Next page, that tax was paid by the check that is deducted from my account. That has been proved. I have an next page number 35.
This is the earlier tax.
Yeah, earlier tax. So I'm placing that at time to time. Next page, page number 36. April to June.
This is the current.
Yes. Thereafter, another tax token. At least 5 tax token I have next year. So now come back the assessment of the authority page number. Page number then
50.
Yes, yes. This is not the correct. Next, permits to be invalid in case of non-payment tax. One might pay taxes because law says if the tax is unpaid, the permit is not valid. But my tax is paid, so I might pay. Now the kindly assessment. Therefore, on the basis of the above scrutiny and observation, the MB tax and additional taxes along with the penalty, other penalties to be imposed on the vehicle number such and such as mentioned below. 17 weeks tax and additional taxes with the fine of equal sum as per subsection C of 2 of section 4 of West Bengal. But according to section 4, subsection 2 clause C of West Bengal Motor Vehicle Tax Act, if any vehicle is registered outside West Bengal, that vehicle is plying in the state of West Bengal and plying without payment of tax, then 17 weeks tax will be realized. Here in this case, my permit is valid, my tax is paid, so cannot assess under this section. If this section is applicable in such a case that if any vehicle is plied without tax token, without payment of tax, then this section is applicable. This assessment will be made under this section. Or this section is not applicable in my case because I have paid the tax. My permit is valid, special permit is valid. Even my regular permit is valid, but I could not ply the vehicle due to non-counter censure by the State Transport Authority of West Bengal. Now, so far the additional tax concern, my lord, motor vehicles additional tax rupees 86,000. See, the tax amount has been assessed only 5,304 because original amount 2,652. This is equal double penalty with penalty double 5,304. Now the second, my lord, MB additional tax rupees 80,632 is the original amount plus 80,000, that is double, and plus 1,000 without permit, that is without valid permit, that is taxes if the tax is unpaid. So that is not applicable. But this is the tax schedule that if any vehicle is ply without registration, the tax will be assessed 2,000 per seat per annum. Very tough. So my lord, before plying the vehicle, it would be thought whether the vehicle is seized, that entire vehicle will be sold to pay the taxes. So my lord, and secondly, penalty on non-payment of tax rupees 1,500. This is not applicable because I have already paid tax. As per section 70-18 of the year, tax is in nothing else. So but the other penalty is concerned without permit, my permit is valid because I have not given the chance to place the within 15 days. So this is also not applicable in this case. And a totally non-application of mine, this assessment is not in accordance with law.
Let the state respond.
Yes.
Mr. Devra, will you come back some other day because?
Yes, because they hearing. Yeah, yes, kindly fix the next day. The next day, hearing a time now.
For learned counsel for the petitioner. Let the matter appear under the same heading for further consideration on 25th July.
20 long demand vehicle right. Sees 20th.
His remedy lies elsewhere.
No. Wrong assessment.
He has to produce before the appellate authority. Section 9 is the authority.
No, other matter is correct. They have not paid taxes at all. My pet is valid. Everything is valid. Any order. I have seen, but they have not paid at all without flying the vehicle, without payment. But everything is valid.
Will you go before the appellate authority?
Yes, that I agree with you. Kindly send the matter within 15 days.
Without wasting further time, I don't.
Yes, it will be better. Kindly dispose of the matter. Yes, I agree. I agree with you.
Mr. Devra should have made this submission earlier. After
But
hearing
that submission is
the-
not required. I have to require key.
Section 9 is there, my lord.
Yes,
Section 9
I agree.
22.
No, I tried my best because my permit is valid. If
But
tax
he
token is
can
there,
produce all the papers before the district
হ্যাঁ, ঠিক
magistrate.
আছে। আমি রাজি হলাম।
The
পড়ে থাকবে কেন?
petitioner
Limitation থেকে
has
আর আগে
essayed
দিয়ে খেলাম মানে তবু আপনি সাবমিশন করলাম আবার ফিজ দেবেন না
limitation থেকে
an order
না
passed
লিমিট
by the
30 days না
regional transport officer Poschim
ওটা বলে দিচ্ছি
Bardhaman
পশ্চিম বর্ধমান।
on 28th April 2023.
হুম
28 to 8. The said order is amendable
না
to
না
appeal
আমি ওকে বলে দিয়েছিলাম
under section 9 of the West Bengal Motor Vehicles Tax Act
আমরা এক
1979
ডিসিশন নিয়ে নিয়েছিলাম
and section 22
22 of the
22
additional.
of the West Bengal Additional Tax and One-Time Tax on Motor Vehicles Act 1989.
Mark.
Paragraph, the petitioner seeks to withdraw the writ petition
2 weeks
and approach the appellate authority
District magistrate.
for
District magistrate
redressal of
appellate
his grievance.
Yes.
Paragraph, in view of the above, the writ petition being WPS such is dismissed for non-prosecution. Liberty is granted to the petitioner to approach the appellate authority for redressal of his grievance. Paragraph, 15 days.
15 days
Limitation lordship can.
Yes.
মানে লিমিটেশন বলকে 30 days because matter is sub judice তো হ্যালো
That is
কাইন্ডলি
what I've recorded, yes.
কাইন্ডলি মেলো
In the event the petitioner
30
Files,
ওভার হয়ে গেছে না
prefers the statutory appeal within 15 days from date, comma, the appellate authority shall dispose of the appeal, shall consider and dispose of the appeal on merits without dismissing the same on the ground of limitation.
and appellate will communicate the decision after taking the decision
Appellate decision, paragraph, the decision taken by the appellate authority shall be communicated to the,
that's yes
this is not necessary. Appellate authority will not communicate. You have to take a
not
certificate.
necessary.
You have to apply for a certificate.
Eh?
Disposed of.
মানে communication is required because we cannot challenge but if I agree মানে if we are agreed so we cannot challenge
First appeal.
Oh,
Not by the appellate authority.
yes we should file the appeal after hearing the appeal so that the appellate authority can
Please do not direct the appellate authority to serve.
after such hearing ঠিক আছে
Yes, hearing matters. No order has to pass, such effect. Hearing matters. You're already crossed the time. If time permits, I'll take up other matters. That is what is recorded today. 156.
no there is
Respondents, your appeal.
Mr. GHOSH and Mr. Shane, because your previous publication directed me to implement Mr. Mr. Shane. Surely appears for legal metrology. I have implemented Mr. Shane along with a copy of the paper book also I have served my lord. It is also.
Where is Mr. Sen?
Because his presence is required. Because my lord, this is the matter, lordship, remember, I have deposited the punitive demand because there was an allegation of overloading. In respect of one train of Kamrup Express, my lord, while coming from Sugar to Howrah, lordship, they had found upon women as per section 78 that it is overloaded. Though in the manifest, I have stated that it is tolerable limit. So, lordship, I prayed for reviewment under section 79. And after that, my lord, I have deposited the punitive demand on protest with the railway, exerting my right to challenge the same before the appropriate authority. Before this honorable court, my lord. Now, my lord, I have filed one writ application, the present writ application, my lord, at the very first day, when the writ application came up for admission hearing, his lordship was to direct them, the railway administration, contact the payment of the FPCA and along also directed the legal metrology to be there. And further directed the legal metrology to see whether the emotion may be functioning properly or not. And report to that extent was directed to be submitted before this honorable court. However, in that particular order, my lord, the railway has come up with a certificate saying that the legal metrology has certified that the emotion beverage is functioning. Now, my lord, when the order was passed for conducting the women,
Mr. Roy, I think it will not be prudent to continue in absence of the state.
because Mr. Sen was very much there at the very, and I have also served, and the was also appearing along with him. The advocate on record, I have served him too. And from the joint report, my lord, it will appear.
Where is Mr. Debra? Where is Mr. Sen? Mr. Sen? Let there be a date in that case, because in his absence, I don't think I should take up. the
He was there, he appeared one matter.
He was here actually. His junior is also not there.
Because, my lord, his presence is very much, without
Let
his
me,
presence.
let
it's
me
very
fix another date. Please intimate him once more. Please take the trouble to intimate him once more.
But I have already served.
Yes, yes, serve a notice, that's all.
I will need not serve further, my lord, I will only intimate.
Just intimate. None appears for the state. Let the matter appear under the same heading on 25th July.
25th July.
Petitioner?
Lord, in this matter, Lord, I have instructions
my
to, I have
affidavit in
instructions to appear for respondent number 6 and 7 for the first time. Because on the other days, the learned advocate who was appearing for 6 and 7, Lord, has been changed due to change of panel. Now, Lord, the thing is this,
That's
Six-
the government of India.
no, 6 and 7 is the, 6 is Salt Commissioner, Government of India,
Yes.
and 7 is the Assistant Salt Commissioner. So but earlier they were being represented, but due to change of panel, there was no lawyer. In fact, Lord, I have instruction to appear for them.
Earlier
I do
occasion,
not-
they have filed the report, man. In compliance of the direction of this honorable court,
Who
they have
is appearing for the 8th respondent?
respondent, man, I am for the railway, man.
I
Other
understand
respondent.
that, I know. 8th respondent, some JK Chem Food Industries.
No, sit.
Who is appearing?
They are consigners. They are only consigners.
Whoever they are, they need to appear, isn't it?
I don't know, sir. I've been told it is served.
Are you ready today, sir?
Lord, in fact, if your lordship, this is for the first time I am appearing in this matter. So if your lordship kindly keeps it, Lord, for hearing so that I can,
Yes,
Lord,
I believe affidavits are complete.
that, Lord, that I do not know, Lord, I have to ascertain whether we have filed any opposition to this writ petition or not, Lord.
Let him come back with instructions. He's appearing for the first time.
অ্যাফিডেভিট ফাইল করেছি, তাহলে আমি তোর থেকে একটু জেরক্স করে নেবো।
আমি ফাইল করেছি, আপনারা রিপোর্টও ফাইল করেছিলেন।
হ্যাঁ, তাহলে আমি একটু জেরক্স করে নেবো
হ্যাঁ,
এগুলো। আমি
চিন্তা নেই।
তোর নাম্বারটা
Report filed by the salt.
9231
Not affidavit.
9231 900
This is a,
Nine?
This systematically produced.
900.
this is a hearing matter. They have
Six.
to prepare
Six.
affidavit. Let him come back with instructions. Affidavit in opposition is being filed by the railways today.
Yes,
They're
yes.
filing it today. Mr. Basu, you've received a copy of this affidavit in opposition?
Yes, yes, yes. That was sir.
Yes, yes.
Reply is on record.
No, man, no reply was filed. That was served long back ago. ma'am.
Reply.
No, no. Opposition was served long back ago.
Reply is not on record.
But I am having a copy. I have read it.
Everyone has to be made ready. Nobody is ready, bro.
I'm ready. চল এক্ষুনি করি। আমি ready আছি।
তুই আমাকে বলছিস nobody is made ready.
So please file the reply.
I have served also the reply,
But it is not on record, if not filed. Affidavit in opposition filed on behalf of respondent numbers 1 to 5 is taken on record. Paragraph learned counsel for the petitioners seeks to use a reply to the said affidavit. Paragraph on prayer of respondent numbers 6 and 7, the matter is adjourned. Take it in. Learned counsel for respondent numbers 6 and 7 seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 1st August.
কিছুই হলো না তাহলে আপনারা হলো না
Same head. Let it retain its.
Please exchange your affidavits in the meantime.
That has been done.
Not, exchange has been done.
Probably it is not in court.
The court is deprived.
They are filed but today.
Next.
I'm grateful.
Item 146 is required to be released.
Please wait, sir. Let me take call the hearing matters first. It has not been called. Yes, 158.
My lord, in this matter, I am for the respondent. My lord, frankly speaking, I am on the impression that those two matter will continue. Today, I am not, my lord, prepared, my lord, this matter. My lord, if he complete the argument today, I have no objection. My lord, on Friday, I shall complete my argument.
I think my lordship will not go.
These are short matters.
These are not short matters. Only one thing, I am submitting that probably my learned friend is representing the Eastern Railway. Right?
Yes.
Now, in this matter, my lords, there are two railways are interlinked. One is Eastern Railway and another is North Frontier Railway. And also when you find the record, there is a file with North Frontier Railway also.
Who was appearing?
But the North Frontier Railway, my lord, after change of management, none of that-
Northeast Frontier.
Northeast Frontier Railway. Lordship, Mr. Chakraborty is there, because the desires, he can get an appearance for the Northeast Frontier. Because he is already representing Eastern Railway. My claim is against the
Northeast Frontier Railway, Mr. Nobu Kumar Dash was representing.
That was late because of.
He is no longer in the, yes.
Not independent.
So in that case, you have to serve a fresh notice, sir. I'm sorry.
Fresh notice?
I cannot, the court cannot appoint another person. Since there has been a change of learned counsels, you have to serve the office once more.
Probably, my lord, I have served them, my lord.
After change of counsel?
After change, I don't know, my lord, who is engaged.
But Mr. Nobu Kumar.
It is, my lord, better to serve the fresh notice to the appropriate authority of that zonal railway.
I want to say one thing, my lord. Already, Mr. Das appeared in this matter, he used one affidavit, my lord.
Mr. Das appears for the union, generally. He appears for the state.
No, after that panel was changed, my lord.
Now he is
He's-
not in the pen.
He is not in the panel.
Panel has also changed.
Everything has to, everything. Now, that is. the
So, my lord, I think, my lord, it is better to serve the notice, at least one notice to the zonal.
The court cannot appoint another counsel. Since there's a change of the panel.
Not a place matter. And in that case, my lord, it's,
Just serve a notice. Because copies have been served.
I have served, they have filed an affidavit.
Serve a notice upon the authority.
Not this particular, one second.
Since this court is informed that there has been a change of learned counsels in the panel of the Union of India, comma, the petitioner is directed to serve fresh notice upon respondent numbers 4, 5, and 6. Notice has to be served upon whom? What is the office?
To the
Who is the appointing authority?
Appointing authority, my lord, it's.
no, my lord, notice is to be served upon the zonal railway. And my lord,
So
there are
upon 4, 5, and 6?
in respect of the North Frontier Railway.
Yes, not frontier, Northeast Frontier Railway.
That is a Malika property. Now, they cannot directly engage a council. They have to send their request to the Ministry of Law here. The Ministry of Law will then engage a lawyer of their choice.
So let it be on 4, 5, 6, let them take appropriate steps.
I will issue notice.
It is, my lord, better to serve the notice upon the respondent number 4, 5,
4,
and
5,
6.
and 6.
Whatever may be the steps,
So that
they
they'll
will
take
take,
steps.
if they will not take steps any, then appropriate order will pass. You will
The
find your
service needs to be shown.
I think of indicated date so that. my lord-
I will do that. I'll do that.
Image them that on this.
Right, I'll do that. Yes. And file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on matter. Oh. Hmm? 7, hearing matter. 28th July, you can serve in the meantime?
The board is sufficient. I will implement them and I will file my application.
Service is what will matter.
Yes, because already they have appeared, but probably who has been engaged by not, I am not sure. Probably after receiving that notice, they may implement.
And Mrs. Chakraborty should be ready in case.
And these are the troubleshooter already. Yes, sir. Now the minor, the system has been introduced that I cannot start directly upon the person getting down. I have to serve upon the department. Department will send the file to the Ministry of Law. Then the Ministry of Law will engage a council.
It's a long chain.
And that takes at least 4-5 minutes by that matter gets involved.
It's a long chain, yes, that's difficult.
Some standing council should be there, my lord, to at least address the court in emergency matter.
Why don't you propose?
That guidance has been taken into consideration by the department. A difficulty is that from ministry or previously it was from railway. Now
It has to come through the ministry.
that is that.
That takes time, of course. That.
And standing council is there.
Shall we go back to the motions? Rakunta?
141 my lord. This one. I am for the respondent.
My lord, contract was executed to the Southeastern Railway on the 7th of December 2018. My lord, pursuant to the contract, my lord, commission has started commencing its operation from 26th of December 2020. My lord. And this is a bi-weekly train of Howrah CSTM Express, my lord. Now, what happened, my lord, after commencing and after operating for 4 to 5 months, my lord, petitioner started facing some operational inconveniences. In the nature of that, the rakes which are required to be placed at the siding, that has a definite timetable. That if the train comes at 6, I will be provided with the rake at 7. So that on the following day, that can be attached. Now, due to delay in running of the train, my lord, sometimes rakes are not being made available to me. Though I pay the freight to the railways, but they could not make me available the rakes. And sometimes, my lord, even after I load the rake, they do not get attached with the train because the train never comes in time. For that reason, my lord, I have lost a seasonable businesses. My perishable items are getting damaged day after day. I brought this issue to the notice of the railway administration for solving the problem, but they didn't do anything. In the meantime, my lord, what has happened? The station was from Howrah to CST, that is Chhatrapati Shivaji Terminus. Well, this was the originating and that was the destination station. Now, during the midst of the agreement, my lord, they have already changed that CSTM station to another what under station, coming under Mumbai division. My lord, another station was changed, but the destination station of CSTM was changed to another place. For that reason, my lord, I made a representation that without taking willingness from me, as per the circular, you cannot change this station all on a sudden. Though there is a provision that in emergency situation it can be done, but suitable notice has to be issued to me. For that reason, my lord, I made a representation that for your decision, I have lost all my client and I cannot utilize it for your difficulty. You have not intimated me. Neither you have taken any consent from me under the provision of the e-policy, my lord, of 2022. Willingness needs to be obtained from me, but that has not been done. So, my lord, after seeing that the railway has not taken any action, I have wrote a letter that I am suspending this operation for the time being. Kindly resolve this issue. Right, my lord, I will take you to page 122 for once.
122.
Page 122 of the data.
Yes, yes.
This is on the basis of a representation, my lord. Can you note the date? It is 26th of May 2023. It states, in reference to the above subject, it's to indicate that this division has reached out partial loan on LBP by train number such and such on round trip basis to be contract between the pair of station mentioned in his contract, it will be assumed that the lease is being operated to and from an intermediate station as the case may be. The above arrangement should continue till the expiry of the contractual period in the normal course. Now, my lord, in case the contractor is willing to extend, first I see the word willing, is willing to extend his lease to cover the newly extended portion, which I have not extended. Also, then the same may be extended and lump sum display charge should be increased on pro rata basis as per his existing discharges for extra distance covered. My lord, if the willingness has been obtained and if I get the willingness, then the for the extra distance which lordship upon changing the station, that I have to pay the extra freight for that. And if I do not agree, then the next provision will cover the issue. However, in case the existing contractor is not willing to extend his lease beyond the starting and the terminating station for which the contract has been executed, then division zonal railway will be at liberty to finalize a new contract for newly extended portion without touching me. For that particular extension, my lord, there will be a separate contract. Now, my lord, they have changed the station. Lordship, kindly come to railways representative page 180.
Yes.
Well, they have also here also, my lord, they have acknowledged this issue. Only the last second last paragraph. All your issues are by forwarded to the concerned department. Page 180. All your issues are hereby forwarded to the concerned department division for further disposal. Any reply from the rate will be communicated to you accordingly, but it has never been communicated. Further, it is also clarified that supply of parcel had not been discontinued from the both end till date other than the operational exigency. Hence, it is hereby requested not to discontinue the operation when guaranteed supply of parcel is assured from both the railways, because such discontinuation of parcel which you have mentioned in your letter will be a breach of contract. I was under compulsion to do it. It is not that I want to do the business. The contract is for 2 years. I have already operated for 6 months. Now, this has a situation which has arose, which needs their interference. Until unless they rectify these issues, they cannot at least compel me to pay the freight, because if I do not pay freight for 3 continuous days, there is a provision of termination. So you kindly see the provision of termination at page 86.
Yes.
So as found page 86, my lord. Kindly see paragraph 19.1 minor from the middle portion. If the contractor for the contract of leasing a parcel fails to pay the lump sum paid for 3 continuous days, he will not be permitted to load in the parcel till all pending dues are cleared. The railway shall have the right to utilize the parcel space as per its own requirement. The contractor shall, however, be required to deposit the lump sum paid for all days, even if the space had been used or partially by the railway on some of the days for which the contractor was not permitted to load on account of non-payment of 3 continuous days. My lord, the only thing I require, my lord, is an assurance from them that they will at least write to me that they have sorted out this issue. With the day they have resolved this issue, I am willing to again start my contract. I was paying them on a regular basis. It is not that I have defaulted. And when the problem has been acknowledged by the railway authority, on the other day, there was a similar matter because she has asked them at least to resolve this issue and not to take any coercive measure. Let them at least assist the court by saying when they will going to sort it.
Let us hear the railways. Yes.
Well, I think there are no provision regarding arbitration. I think so. Arbitration, if arbitration is there, that can be solved any time. But as far as this case is concerned, my lord, there are, my lord, another station provision is there in special service. Normally it has not, but there are no reply regarding, my lord, petitioner is concerned, my lord. What is the difficulty? See short form. One station to another, there are no difficulty. They are all good station, infrastructure is there. Other contractor also.
Not providing the rate in time for him to load.
That is their allegation. But as far as this,
And you have accepted the allegation.
yes.
Please come to page 122. That is where you have accepted.
the
So you need to apprise the court as to what further steps have been taken by the authority pursuant to this letter.
Your Lordship, you should kindly give me some time that I can take instruction from the client in elaborately.
So in that case, please come back on affidavit.
Yes,
A report in the form of an
yes,
affidavit.
yes, that would be better, ma'am.
In the meantime, no coercive action.
That can be, my lord. Short time, my
You
lord.
have acknowledged the difficulty, the
Yes,
problem.
yes.
Affidavit of service. The grievance of the petitioner is twofold. Firstly, the petitioner has been facing operational inconveniences for not being provided with empty rakes. What is it called? Empty rakes
On time.
at the terminal stations.
Yes.
By the authority in time for loading his consignment. And secondly, the destination station has been shifted.
Yes. CSTM to White Lantern.
The destination station has been shifted by the authority from CST to
White Lantern. WADI
WADI without intimation to or consent of the petitioner. Paragraph. In a letter issued by the Divisional Commercial Manager Kharagpur to the senior, this is OM is Operational Manager, Divisional Operational Manager within brackets CO, C small o, capital C small o, bracket closed, Kharagpur, Southeastern Railway. On 26th May 2023, the authority has acknowledged the inconvenience of the petitioner and has requested the senior divisional operational manager to look into the matter. Paragraph. Learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard. As to what further steps have been taken by the authority pursuant to the letter dated 26th May 2023. Paragraph, let the matter appear under the same heading on 2nd August. Sorry, let it be 1st August here. 1st August 2023, paragraph, no coercive step be taken by the authority against the petitioner in respect of the consignment in question in the meantime.
My junior name may be recorded. She is now online.
Your Lordship, I'm appearing on.
Full naam to record.
I have what it should be WAD even.
Oh, Kamlan. Report. Yes, next.
Report in the first, say, 1st of August. 1st of August. Date today, date.
In answering respondent in South Bengal State Transport. Mr. Owen Banerjee is appearing, my lord.
Have you served?
His presence is necessary.
Have you served the South Bengal? State
Since they are falling under the state, my lord, so.
State is not the.
Allocation for
Serve
SPSTC, South.
A separate set of councils represent the South Bengal. So will you serve and come back?
Sir, may I be permitted to plead the matter, my lord. Respondent number 2, my lord, issued a work order.
In absence of the South Bengal State Transport?
The state.
Mr. Devra is not representing the South Bengal State Transport Corporation. There's a separate set of councils for, so please serve and come back. Okay? Affidavit of service. Since service of respondent numbers 2 to 5 is not complete, comma, let the matter stand over till 2nd August.
The time keeps in July. The second week of July.
Not possible. 27 July.
My lord.
So,
My lord, in this matter, Mr. HON'BLE is appearing in paying for not today, my lord.
not today, it's almost time. Not today.
So the evidence of service kept on record.
Not to,
I have been.
in one of the matters, the petitioner wanted to get the matter released. Which matter is it?
145,
144, I have.
বুঝে petitioner না থাকলে রিলিজ করে দিচ্ছেন জজ।
One matter, petitioner এক্ষুনি বললো না, release করতে চায়, which matter?
146. 146.
Hearing 144.
9. Revenue matter, that should be before code number 9. Somehow, on 144.
So he wants to get it released. So does it have determination? 146 chapter, huh? এখানে নাম্বার বলে আছে কত নাম্বার কত হবে
That is, with regard to 4th stamp paper.
তাহলে 55 হবে এটা রিলিজ করে দিচ্ছি what is the number, what is your petition number?
136.
The number,
নাম্বারটা
14253. Right? 14253.
this has been wrongly recorded. 14253 is not in the list at all. It has been wrongly recorded in the list. It will be 14255.
Oh.
So let us stop here today.
পিটিশনের
No,
নামটা
this is
দেখে
Rabindranath Das.
Dhurjyoti Das.
This is Rabindranath Das.
রবীন্দ্রনাথ তাহলে ভুল এসছে।
So it is wrongly recorded in the list. It is not your fault. ঠিক করে দিন, ঠিক করে দিন, কিছু করতে হবে না।
তাহলে এটাকে ডিপার্টমেন্ট ব্যাক করে যাবে।
তোমার মামলাটা আসেনি, এটা ভুল করে।
আচ্ছা আচ্ছা।
Your matter is not in the list
Oh,
actually.
I am not in
It
danger.
has been wrongly recorded. না না না, সেই জন্যই উনি মুভ করছেন। Bad luck, Mr. Chatterjee, next matter was yours.
No. Sara, then my.
Bad luck. Next.
তোমার 40 করে তো পিটিশনারই ছিল না। কালকে প্রথমে